2011, it had gone on so long and they weren't paying any money to us at all. Once again, we were in a position where we were paying the mortgage, still paying the electricity, still paying the water, and I was no longer getting a salary from Connaught. And he was intermittently reimbursing expenses. So, our position was starting to become really difficult, which is why, we started having that discussion in Barcelona, precipitated, as I said, by people of our age, moving on. And, because I needed to get something on a level because we were not earning we weren't getting any money from the Gunbies. They weren't paying anything towards the house at that time. And nor was I getting paid by Connaught, apart from small sums of reimbursement. But they were reimbursements. That's cash that I'd laid out. That was nothing that was coming back. So, yeah, that's it.
Mr. Withers brought up something in his opening statement about how you told Mr. Gunbie that the deal did not end. Do you remember that?
Yeah. That was in an email. That was in an email that I sent to him in, I think, August 22 or something. I can't.
With you. And this is marked by defendants 5.
So
this is a September 10th, 2022 email where you stated, I mentioned that as the deal did not end in July 1st, 2021, I was now carrying the monthly mortgage, tax, and insurance when I anticipated this would be gone.
Yeah.
What did you mean by that?
Well, I think, as we said at the deposition, that there's a context to this. I know Mr. Withers has a different view, but what I mean by this, this letter is a request for them to start paying some money towards the house because it was getting difficult for us. So what I meant by the deal did not end was that the Gumbies did not end the deal. They didn't buy the house. They didn't close on the house.
What exhibit?
Yeah, they were still there.
This is defendants 5, Judge. I don't think you have a hard copy of this.
Okay. No, I mean, I can see it on the screen. I just was like, I don't think I have that document here. So, okay. Thank you, sir.
So they were continuing to live in the house, but not contributing anything to the house. And I said, hey, okay, carry on living in the house, but you need to at least pay the expenses. Now, I didn't ask them for market rent or anything because we were in business together and, our business was, a little bit shaky. So I said, just cover the expenses again like you were doing previously. All right. And that's what this letter is about. So when I say that the deal did not end, it didn't end because Gunbie didn't buy the house, not because the agreement didn't end.
Okay. All right. I know we've touched on it a lot, but tell us about when you and Mr. Gunbie or you began working with Connaught and what that is.
Right. So Matthew sets up a company maybe during the time he was with EY or maybe after he just left. I can't really remember. And the intention was to do similar business in the Middle East that he'd been doing with EY. And he asked me and a number of other folks if we would participate in that venture. And he offered me a position as chief operating officer for that. He said that he had capital funding for a year and that would give us enough runway to build a business. And that's logical, it's fair enough. So I started working for Connaught in the Middle East in June, I think, June 22. June 22, yeah.
All right, I'm going to share another exhibit with you. This is plaintiff's 5, and this is your Connaught employment contract, correct?
Yes, it is. Yeah.
And it's signed June 1st, 2022.
Yes, it is.
All right, and this was for a 2-year term?
Yes,
And under this agreement, you were supposed to receive a salary?
yes.
What was the salary?
It's about 15,000 and something Bahraini dinar, I think. No, maybe. It's in there. I can't remember, honestly. It could have been 15, maybe $15,000. So yeah, for 15, it works out to be, there you go. So 4,000 dinars.
And what's the equivalent of that in US dollars?
It's about, with all the expenses and the travel and what have you, it's about around $15,000 a month. Yeah,
In US dollars?
in US dollars. I think it's like 2.6 is the exchange rate, Bahraini dollar to a dollar. It's a very strong currency.
And what was Mr. Gunbie's relationship to Connaught?
He was the owner and the chief executive.
And did you receive a regular salary from Connaught?
For the first 6 months, yes, I did.
And then after that, what happened?
After that, I had 2 months of half salary and then no further salary.
Mr. Downs, may I ask, or Mr. Badham, so the document that you're referencing is Exhibit 5, correct? Plaintiff's Exhibit 5. And at the bottom, it says Connaught Services WLL. Is that something that is designed to indicate as an Inc. or an LLC would in the United States that this is a corporate entity?
LLC.
With similar corporate constructs and protections
Yes.
under Bahraini law versus state U.S. law?
Yes.
Okay, thank you.
And how did you receive payments from Connaught?
I received payments directly to an account with an organization called Wise. Both Matthew and I use that. It's an online bank. And it's very easy to work. You know, we were working in British pounds, we were working in US dollars, we were working in euros, Bahraini dollars, and it makes it really easy to transfer money around and switch currencies and what have you. So he paid me directly into my Wise account from his Wise account.
So when you say Matthew paid you directly, you mean Matthew personally, not from a company-wise account?
Yes.
So all the payments you received from Connaught were personally from Mr. Gunbie?
Yeah, I only ever received money from Connaught from Matthew's personal, for Connaught from Matthew's personal accounts.
So let me make sure I'm following that because you correctly anticipated why I was asking that question. So the payments that were due to you from Connaught under this employment agreement, you did receive those payments.
Some, yeah.
But they were physically paid to you from a personal Wise account held by Mr. Gunbie.
Yes.
Okay, thank you.
And did you get paid everything you were owed from Connaught?
No,
And
I didn't.
how much would you estimate you were still owed in salary?
About $236,000.
Is Connaught still in business?
I don't believe it is.
Did you ever ask the Gunbies to vacate Colby Court?
Yes.
And when did you do that?
Formally, I think on the when I sent him a WhatsApp message in April of, it would be maybe April 17th, I think, that I sent him a WhatsApp message. But we've been discussing the possibility of this for ever since that October email that you showed me.
What year would that be?
2024.
So in April of 24, you sent him a formal notice through WhatsApp.
Yeah.
What happened when you asked them to? Well, let me ask this: why did you ask them to vacate?
Because we needed to come back to the United States. Our position had become untenable. We were receiving no money from Connaught. We still had all the expenses of Colwood. We needed to rent a property in our house in Spain. We didn't own a property there. We were just renting. And our position had just become untenable, and we were running out of money. And my wife couldn't work in Spain. She didn't have work authorization. I didn't have a job in Spain. There was no money coming in from Connaught. So we said, you know, the only way we can get ourselves right here is we need to move back to the United States. And I'd been having this discussion with Matthew since the previous October, because the business wasn't generating the revenue that we anticipated it would. And we had some opportunities, we had some prospects, but nothing crazy. And I mean, it got to such an extent, honestly, that luckily I managed to find a way to put a mortgage on a previously paid off condo in Atlanta, which would then give us some breathing room. But it got to us, but that didn't kick in until April of 2024. And then it got to such a state that, you know, the last month's rent that we paid in Spain, I had to sell a watch that I'd been given from my father. And I was very embarrassed about that, in order to just pay our rent. And that's really where the whole thing finished for me. We need to come back to the States, get ourselves a level. Liliana goes back to work at the hospital, and we can start to get ourselves well. Our son goes to high school here, which is something that he wanted to do, and maybe go on to a college track here in America. He was born here. He was born in Atlanta. So he had this idea that he could come. Riverwood High School in our school district is a great public high school. They do the International Baccalaureate, and all those things were played into our stuff. So we had to come back really because we had no more options.
And what happened when you asked them to move out, the Gumbies to move out?
At first, Matthew said he was devastated. He'd have to think about it. He said he would have to get with Kim and see if they could work it out. Then he sent me a long email basically telling me that I was unfair, unjust, unreasonable, that, you know, it would really damage him, and, you know, absolutely no consideration for our position, you know, just for himself.
Did that response surprise you after all that's happened?
Yeah, it did. It did. I was very hurt by it, actually. I was shocked. I was shocked by it. I was hurt by it. And I continue to be like that. I mean, I pray on this every single day because it astounds me, honestly, their action. Yeah.
And they didn't vacate the property, correct?
No.
And when did you want them to vacate by?
You know, I said to Matthew in April, listen, you know, Felix starts school in August. It would be really good for us to be in before then. You know, so anytime, so around the 15th of July would be great for us. It's 2 weeks before school starts, and that would help us out a lot.
And instead of vacating, did they have an attorney send you a legal notice?
Yes, they did.
Just to make sure my notes are right, you asked them to vacate or maybe first broach the subject in April, but the time frame that you wanted them to consider vacating by was in August.
Yeah, in order for school to start in August, so late July.
Okay.
Yeah.
All right. And I'm showing you what's marked as Plaintiff 7. Is this a copy of the legal letter you received from Arnold Golden Gregory?
Yes. Yes, it is.
And this is dated July 1st, 2024, correct?
Yeah.
And
because if I could add, I mean, before this came, they didn't tell me from April through to actually a WhatsApp that Mrs. Gunbie sent eventually. They wouldn't tell me that they weren't going to move out. And we were trying to move and get movers and pack up our stuff. and they wouldn't tell me. They wouldn't agree. They wouldn't say whether they were going to move out or not. So it was really just unnecessarily difficult. And then, of course, we end up getting this letter, which was a complete shock to me. Yeah.
And in this letter, it references, kind of similar to your testimony, that in April 2024, you advised the Gumbies of your request that they vacate and surrender possession on or about July 12th, 2024.
Yeah.
Which is more than 60 days notice, right?
Yes.
Oh. In this letter, it says that the Gumbies have paid over $408,000 towards the purchase price. Do you see that?
Yes, I do.
Okay. Do you agree with that?
No.
And so what did you end up having to do since they didn't vacate Coldwood Court?
Well, we had to hire you. We needed an attorney to respond. We then had to put all our goods into storage, and all our goods are still in storage in Spain. And so we've effectively been living out of a suitcase for, nearly 18 months now. Yeah, we had to rent a property close to the school, which we managed to do, and we're still in that rental property now. Yeah.
What type of rental property is it?
It's an apartment building, but we have a little townhome at the bottom. But the square footage is the same as the apartments. It's just the way the apartment building works is that the ground floor is in one of the buildings are restaurants. So obviously they have a bigger ceiling height than the apartments. So in our block, they just built effectively a little townhome. So we have an upstairs and a downstairs.
How much do you have to pay in rent on the townhome?
$3,666 a month.
And is that more than your mortgage payment?
Yeah, $1,400 more than my mortgage payment.
And those are different properties. You're renting a townhome versus the Coldwood Court's a single family home.
Yes.
Did you look into renting single family homes?
Not really, because we had to, we didn't have our stuff. All our goods were still in storage in Spain. In order to rent a single family home, we would have had to bring our goods, and it takes 3 months to get things over from Europe. And we needed to be here quickly. We had to move in a few weeks because of the uncertainty that the Gumbies created around our move. So it was much easier for us just to rent in an apartment building that was quick and easy.
Right, and I'm showing you what's marked as plaintiff's 8. You mentioned having to hire an attorney. Did you have to hire our law firm?
Yes.
Okay. And did you have our law firm respond to the Gumbies attorney's letter?
Yes, I did.
Okay, is this a copy of that letter?
Yes, it is.
Okay. And in this letter, you had our firm demand possession of the property, correct?
Yes.
But that still hasn't occurred. They have not returned possession, right?
No, they haven't.
So ultimately, you had to file an eviction on them?
Yes.
And are you seeking reimbursement of your legal fees for having to file the eviction?
Yes, we are.
All right. I think you may have mentioned this, but what is the amount of your mortgage payment, monthly mortgage payment on Coldwood?
Currently, it's 2,300 and change.
And have you been paying the mortgage the entire time the Gumbies have lived there?
Yes, I have.
Have you ever defaulted on your mortgage payment?
No, I haven't.
And what utilities are you currently paying on the property?
I'm paying for electricity and water, plus pest control and a lease on a air conditioning system. But I guess they sort of belong to the house. Yeah.
And what,
I'm sorry, you said water,
Electricity,
power and the lease on the air conditioning
Yeah, and pest control.
and pest control. Thank you.
So what are your monthly expenses then for carrying Colwood Court?
Okay, I'm gonna have to add that up now. So it's 2,300 and something, 451 for electricity because I'm on a budget number. So no matter how much they use, it goes up and down. $62 for water, and I don't know what they miss out a month, but then it's $100 plus or minus every 3 months for pest control.
And is that adds up to more than you're currently receiving from the court for the registry payments, correct?
Yes,
Have you been paying the property taxes on the property?
yes,
And have you ever missed paying the property taxes?
no,
Have you been paying homeowner's insurance on the property?
yes, I have.
Do you recall what the amount of your homeowner's insurance is?
I don't.
Have you researched what the fair market rental value of Colwood Court would currently be?
Yeah, it's around $5,000 a month.
What did you do to form that opinion of value?
I looked on the rental websites. Zillow has it at for 400, I think, and then Redfin has it at 5.1, and then I have a friend who lives around the corner who is renting their house, which is a little bit smaller now, certainly doesn't have a swimming pool, and they're renting it for 5,000. So plus or minus $5,000. Yeah.
And if you were to get possession of the property back from the court, would you be looking to move your family back into Colwood Court?
Absolutely.
You would not be looking to rent it out.
No.
You've testified about other amounts that Mr. Gunbie owes you, but you're not seeking those in court today, right?
No.
You're aware that the Gumbies are claiming that even if they have to vacate the house, they should be able to recover the value of the improvements they've made to the house?
I am aware of that, yes.
Was there ever any agreement between you and Mr. Gunbie concerning who was responsible for, that you would be responsible for paying them back for improvements made to the house?
No. They were responsible for maintenance, and that's it. Yeah.
Was there ever any agreement that you would reimburse them for maintenance costs?
No.
Did the Gumbies ever ask your permission to make any improvements to Colwood Court?
No.
Are you aware of what improvements they have made?
Before the fact, I was aware of the retaining wall and the roof because they asked me about those because we wanted to get the insurance involved, my insurance involved. But that was it, nothing else.
Would you have expected Mr. Gunbie to ask your permission before making improvements to the property?
Yes, I would. I would, at least to talk about it. I mean, at least to say, hey, we've got these plans and we're doing this and we're doing that. I mean, at this point, just for reference, I mean, Matthew and I were living together. I mean, we were sharing a house in Riyadh. And so we spent a lot of time together, and, you know, he shared the most intimate details of his life with me, but he couldn't tell me that he was going to put a fire pit in or whatever he did, a gazebo or something. I mean, it begs belief, honestly.
Is there anything else that I haven't asked you today that you would like the court to consider?
I mean, I've sort of hinted at it, but honestly, these people, we considered them our friends, and we helped them and are continuing to subsidize them. since 2013. And like I said, I'm still shocked at the way that they've treated us. I'm shocked at the expectation that they have after everything that they've received from us, the kindness and generosity and support. I mean, I've hinted at that before. And I'm really, and I'm upset for our son who, is having to navigate his high school years living out of a suitcase and, not having the house that he thought he was going to come back to as he went into high school. Yeah. So there's an emotion there. And like I said, I pray for these people every single day. And
Thank you.
Nothing further.
Mr. Withers? Before you get started, I don't think this matters, but I did just connect something I wanted to make sure you're both aware of, right? So Mr. Withers' partner, Chesley McLeod, and I are related. Our grandmothers are sisters. I don't think that matters for anything, and I couldn't even do the flow chart of the amount of relation that we are. But because we are related, I just clicked in my head AGG when I saw the attorney letter that was Exhibit 6, I think, or maybe 7. And so I just wanted to make sure and put that out there so y'all are aware of it. Go ahead, Mr. Withers, if you have questions
for you.
It's like your cousins or something.
We are, and I think it's several times removed, and but anyway, Mr. Withers, whenever you're ready and you have questions for this witness, sir.
Sure. Give me just a second to get set up here. If I may approach, Your Honor, I have
Sure.
our exhibits.
And were these intended to be the official court exhibits that you gave me, Mr. Downs? Because I treated them as my own and wrote notes on them.
No, I
Okay.
mean, you can, that's your copy.
Okay.
I've
And
got a separate copy.
I'm sure the court reporter will appreciate, and I think the rules require that within 10 days of the completion that y'all provide those
I've
documents to
also
her.
got another.
Electronic
standing
format.
order set of
Exactly,
I've got
to the
one
court
copy.
reporter. Perfect. Thank you.
Good afternoon, Mr. Badham. Are you currently employed?
no,
You were last employed in approximately May of 2024, correct?
yes,
And I can't remember whether you testified as to this point or not, but you moved to the Atlanta area in 2001, is that correct?
yes.
And purchased, I'm sorry.
Yeah, that's all, yeah.
And purchased the Coalwood property in approximately 2005, right?
2006.
2006. And when you bought that property, you paid approximately $350,000 for it?
368, I think.
Okay. And the current balance on the mortgage that we've been talking about today, do you know what that is?
Yeah, it's approximately 140,000.
And once you bought the property, you lived there for about 5 years.
Yes,
And you moved out of the property in 2010.
yes,
And from 2010 through 2013, you and your wife allowed some of her relatives to live in the property.
yes.
They did not pay rent during that period.
No, they did not.
Did they have a rental agreement?
No, they did not.
And from 2010 to 2013, you visited the property on average maybe once a year, right?
Yeah.
And you tried to sell the property in 2013, correct?
That's correct.
But you do not know what the appraised value of the property was at that time, do you?
I don't recall it.
Now, you met, I believe you, or maybe you testified that you met Mr. Gunbie in the early 2000s. Is that right?
Yeah, when I met Matthew through business when I moved to the US to take up a position for the UK company that I was working for that had got business in the United States.
Okay. And so you allowed the Gunbies to move into the property in 2013, right?
Yes.
And I believe you testified that Matthew, Mr. Gunbie, approached you about moving into the property.
Yes, he did.
But in truth, it was you that first mentioned the possibility of the Gunbies moving in, not the other way around. Isn't that correct?
No, that's not correct.
Okay. In any event, you did not enter into a written lease agreement with the Gunbies at that time.
No.
And in fact, you never entered into a written lease agreement with the Gunbies relating to Coalwood property at any point in time, did you?
No.
I believe you testified that you discussed that the Gunbies would pay $1,400 a month to live in the house?
Yeah, well, initially I wanted more than that. I wanted the cost of the mortgage, like I said. But he said he could only afford $1,400.
And the Gunbies did not make those payments consistently, did they?
Not for the first 15 months. They didn't pay any. They didn't make any payments. Oh,
You continued to allow them to live in the house.
yes, I did.
Just to
And-
be clear, you're talking about the first 15 months in 2013, they didn't make any rental payments,
2013
correct?
to 2015.
Thank
Yeah.
you.
And you never sent them any default notice, did you?
No, I did not. Because they were in trouble and trying to get back on their feet. Why would I be generous and, helpful and supportive of somebody I considered a friend if I was going to hassle them every 2 minutes?
There did, as we've discussed, there came a time where you began discussing that you would sell the property to the Gunbies, correct?
Yes.
And those discussions initially began in 2016.
Yeah. Yes.
And at that time, Mrs. Gunbie commissioned an appraisal of the property, correct?
Yeah, she did.
And you don't know what the appraised value was at that time, do you?
I don't know.
Okay. But in any event, you and Mr. Gunbie ultimately agreed on a purchase price in the principal amount of $450,000.
Yes.
And the two of you ultimately reduced your agreement by which you would sell the property to the Gunbies into writing, correct?
Well, we have to put this into context. We agreed a sales price of 450 because that's what Mrs. Gunbie would accept. But we were going to roll into our agreement all the other monies that were outstanding for him, just so we're clear on that.
Okay, and I do want to be clear, and that was on May 5th of 2018, right?
Yeah.
Okay. Your Honor, do we want to do the same exercise that we did with my exhibits, just so we can speed things along?
Indeed, yes, sir.
Okay.
Mr. Downs, have you had a chance to review the exhibits they intend to offer, and are there some that we can agree to?
Yeah, I'm fine with all of the correspondence between the parties. I do see defendant's discovery responses, and I don't really understand that one.
Okay, well, we'll leave that one open for now.
I don't understand the deposition transcripts either, because both of the witnesses are here to testify.
Well, he might want to impeach with them, and so I'm sure in an abundance of caution, he's including them in case he wishes to do so, and
So, yeah,
we'll leave that one open for now as well,
Okay, yeah.
those two.
leave that open. I don't have any issue with the other ones.
Okay, so just for record purposes, D1 has essentially already been admitted as P1. It's the same document, correct, Mr. Withers?
I'm sorry, can you repeat your question?
P1, the actual purchase and sale agreement has already been admitted as P1, right? So,
Right.
and then Mr. Downs indicated he had no objection as to D3, D4, D5, D6, D7, and D10. Is that correct, Mr. Downs?
That's correct.
And so those documents, those exhibits will be admitted for use. And we're going to leave open D2, D8, and D9. So whenever you offer those, you'll need to lay a proper foundation other than just going ahead.
Sure.
Okay? Thank you, sir.
Okay. So, and I'm, for the benefit of Mr. Gunbie, who's viewing this remotely, I am showing you, or I'm putting up on the screen what's been marked as Exhibit D1, which again has already been admitted by your counsel. So you recognize this document, of
Yes, I
course.
do. Yep.
You don't recall whether it was you or Mr. Gunbie who drafted this agreement, do you?
Yeah, we drafted it together. I mean, we had various iterations of it and then this came up. Yeah.
So, but you don't remember who drafted the first iteration of this agreement, do you?
Yeah, I probably did. I probably drafted an iteration, but honestly, it went backwards and forwards and this was a mutually agreed document.
And it says this document details the agreement made between the parties to the agreed sale of the above mentioned property by Keith Badham, seller, to Matthew Gunbie, buyer, right?
That's what it says.
And you a minute ago, you said, well, let me strike that. It says that the sale price of the property is $450,000, right?
Yes.
But you.
Plus interest.
Plus interest at 5%, right? But it's your testimony now that really it was something much greater than that is really what you were expecting.
My testimony isn't any different than I've given you before. The whole purpose of doing this was to say, hey, we want to roll up everything that you owe us. This is the sale price of the property. All the other stuff is there. And that is why on the spreadsheet, which you mentioned before, it says 450 plus X plus Y plus B.
Trying to understand what the agreed sales price of the property was. This document says $450,000, but you're saying that really the agreement was $700 and some odd thousand. Is that right?
Well, the agreement was that he would settle $742,000 by the end of this term.
Okay.
But $450,000 of that was the sale of the property.
Okay. Is there anything in this agreement that talks about any other amounts owed?
No, there is not.
Okay. And it says 100% of the loan finance to be provided by Keith Badham, correct?
Correct.
But you did not actually make a loan to Mr. Gunbie, did you?
No.
You just agreed to accept payments from him over time, right?
Yes.
And section 1 is entitled Loan Repayment Schedule and Deed Transfer. And it says it is proposed that the following buyer payment schedule will be as follows. And it says 37 payments at $8,000 a month commencing on June 30th, 2018, and a balloon payment of $205,522 on June 30th, correct?
Correct.
And so if we add up the 8,000 times 37 equals $296,000, right?
Sorry, what did you repeat?
Right. If we times 37 months, that equals $296,000.
If you say so.
Okay. And I'll represent to the court, that's the math. And then, so if we add the $205,522 balloon payment, that brings us to a total of $501,522. I'll just represent to you, that's the math. And that number includes both the principal and the interest through June 30th of 2021, correct? I need you to answer verbally, so.
Oh, yes.
Sorry, no problem. Court can't take down nods.
I got that.
Okay, I'll do that. And it says within 30 days of the last payment, the deed will be transferred, right?
Yes, it does.
Now, section 2 of this agreement is entitled Conditions. And section 2.1 says, the price is fixed by the seller as of the date of this agreement, right?
Yes.
And again, that price is $450,000.
Okay.
And again, just so we're crystal clear, this document says nothing about any amounts above $450,000 beyond the interest, right?
No, it doesn't.
Section 2.2 says buyer will cover the cost of all wear and tear repairs necessary during the life of this agreement, including maintenance. All utilities will be transferred to the buyer's account. Do you see that?
Yes, I do.
And you understood wear and tear to mean maintenance, right?
Well, it says including maintenance.
Right, and that's what you understood wear and tear to mean as well, right?
I understood it to mean the necessary work that one is required to upkeep a single family home.
You did not understand it to mean capital improvements though, right?
Probably not.
You've been a renter for many years, correct?
I have.
And in all the time you've been renting residences for the last 15 years as a tenant, you've never paid to have an HVAC system installed in any of your residences, have you?
No.
And you've never paid to have a water heater installed, have you?
No.
And you've never paid to put a new roof on any of the residences you've rented, have you?
No.
And you've never done major repairs to those residences out of your own pocket, have you?
No.
Section 2.3 says if buyer wishes to cancel this agreement at any time and for whatever reason, no payments will be returned nor value given for any repairs or improvements which will belong to the property. Do you see that?
Yes, I do.
And so you understood that in addition to repairs, that the Gunbies might be doing some improvements to the property.
Yeah,
Okay.
but if I can clarify that, I already told them, listen, if you want to paint the walls, be more comfortable. If you want to redo the garden, be more comfortable.
Right. And
That's what I had in my head.
right. And obviously, once you put the paint on the wall, you can't take that with you, right? If they move out, of course, the paint's going to belong to the property, right?
I guess.
And the gardening is going to belong to the property, right?
Well, you could remove plants if you wanted to move it. I mean, I don't want to be, flippant, but what I'm telling you is that that's what I understood it would be. If they were going to make, things other than repairing leaky roofs or dealing with the plumbing, then it would be in that sort of dimension and that sort of context.
So when you said any improvements will belong to the property, you meant paint on the walls and plants in the garden.
What I meant was, do what you need to do to make yourself, more comfortable within reason. I mean, really, I didn't have anything specific in my head at all.
It says, section 2.4 says, if buyer fails to make any payment for 6 months, then the buyer is assumed to have canceled the agreement per section 2.3 above. Do you see that?
Yes, I do.
And section 2.5 says any taxes or fees associated with the agreed transaction are the responsibility of the buyer, excluding the federal and state income taxes of the seller. Property taxes and insurance will remain the responsibility of the seller during the term of this agreement. Do you see that?
Yes, I do.
And your counsel was asking you about whether you were continuing to make, paying the property taxes and the insurance. Do you recall him asking you that?
I do.
And of course, you expected to make those because that's what you'd put in this agreement, right?
Well, I would make them irrespective of this agreement, but yes.
And so you never expected the Gunbies to pay any property taxes or insurance, did you?
No, I did not.
Okay.
Well, not homeowners insurance, but I absolutely would have expected them to have renters insurance, and I don't know whether they had that or not because I never asked.
Okay. Section 2.6 says if the seller wishes to cancel this agreement, notice must be provided in writing. All payments made by the buyer prior to the notice of cancellation will be due back to the buyer within 90 days of such written notice. Do you see that?
I do.
Section 2.7 says during the term of this agreement, the buyer will have the right to occupy the property as a private residence, and no rental payments will accrue or be payable. Do you see that?
I do.
And Mr. Gunbie signed this document as the buyer,
Yes, he did.
and you signed it as the seller.
Yes, I did.
As you sit here today, you don't know how much the Gunbies have paid towards the $450,000 purchase price principal, do you?
Yes, I do. They paid $114,416.
Bear with me 1 second.
Is that, while you're looking that up, is that reflected on the spreadsheets
It is.
minus the utilities payments that you were also making?
No, they're listed separately
Right.
on the spreadsheet. So you'll see that during the term of the agreement, between May, whatever the date is here, May 18th, through to June 2021, you'll see that they paid $114,416. The utilities are separate.
Right.
They're over and above that.
That's what I was clarifying, is that your 114,416
Okay.
is just for the payment, the contract payment, not including the utilities amounts. Okay, thank you. Go ahead, Mr. Withers. Sorry for the interruption.
Sure, just a second. Okay, and that's the amount that they paid, that $114,000. That's what they had paid through June 30th, 2021, right?
Yes.
Okay. So I want to direct your attention, if you'll look at Exhibit D2. You recognize this document.
I can't see it. Yeah.
Oh, I'm sorry. Let me put that up. There we go. And it's also in your binder there. You recognize this document, correct?
Yes.
These are the Gunbie's responses to your discovery requests in this case, correct?
Okay.
Do you acknowledge that?
Yes.
And you've read these documents, this document, correct?
I think so.
And you were asked about this document in your deposition. Do you recall that?
I don't recall, but if you say so.
Okay. This is a true and accurate copy of the discovery responses that you received, correct?
This is the one I'm going to object to. I mean, maybe this is proper, but not for this witness, it's not his discovery.
I think they're admissible because they're part of the case. I think that I'm going to interpret your concern or objection to be one of materiality to this particular witness's testimony. Can you?
Sure, I'm going to ask him, this documents a number of payments that my clients made, that I think he will, agree that he received. And I just want to go through look at the payments and confirm that he received those. He testified about them in his deposition. These are questions that he propounded in this case to my client. My client provided verified interrogatory responses to these, to his discovery requests.
So let me say this way, with or without reference to these interrogatory responses, or I don't know if they're, looks like RPDs and interrogatories. Basically what you, as I understand what you intend to do with them is, Mr. Gunbie says he made this payment. Did he make this payment? Mr. Gunbie says he made this payment. Did he make this payment? Is that
That's
roughly
essentially
accurate?
it. I'm going to ask about some of the improvements to the property as well.
Okay, Mr. Downs?
Yeah, I mean, I think you can do the same thing by just reading from the interrogatory responses instead of admitting them. I mean, it's, the interrogatories themselves are hearsay under the law,
Sure.
without the foundational documents. And these are,
Well, except to the extent that they're admissions by the parties.
yeah, and if he's testified about this previously, then he can talk about that. But this witness to put into evidence their client's payment history, I'm not sure is proper.
Well, I think that I don't know if this is actually part of your record in the docket, because depending on 5.2, y'all usually just file certificates saying, we filed an answer, we served this, we did this. So to the extent that the substance is here, I think it is potentially helpful to the court. I agree with some of Mr. Downs' concerns, but to the extent that you're basically using it as somewhat of documentation of this is what Mr. Gunbie has said, do you agree or disagree? I think it gets us to the point faster, and so I'm going to allow it.
Okay, thank you.
Could we just allow the relevant portions of the interrogatories?
That's fine.
Sure. I mean, in truth, it's similar to, in my opinion, to a deposition, right? That if you ask him, Mr. Gunbie said he made a payment on this date, and he agrees that Mr. Gunbie said that, or that Mr. Gunbie in fact did make that payment, there's really not any reason to reference the discovery responses. Similar to, unless they say something different than their deposition, there's no reason to introduce. So,
well, I would also say, Your Honor, I mean, there were, we're not talking about 3 or 4 payments. We're talking about tens of payments.
okay.
And, same thing with, so, I mean, I could certainly go through each one and ask him about each line item payment. I just want to avoid.
No, I'm not asking you to do that. I think we'll know better in a moment what portions of this D2, which is just to my grabbing whole 25 plus pages. Yes.
Right.
And so I think we'll know in a moment which parts you're actually referencing.
Yes,
and I think Mr. Downs' point is a valid one. So what I'm going to say is I'm conditionally admitting D2 to the extent that you're going to reference particular aspects of it, and I will admit those aspects of it.
Thank you.
Okay, thank you.
So, Mr. Badham, if you'll turn to interrogatory number 8, which is on page 4.
Are you putting it on the screen or do I have to do it in the book?
Oh, I'm sorry. I'm going to do my best to try and multitask here. Okay. So, showing you interrogatory number 8 on page 4, and in discovery, you asked for each of the 37 payments at $8,000 per month, commencing on June 30th, 2018, as required by the May 5th, 2018 purchase and sale agreement. Attached to the answer is Exhibit A. Please state the following, and then it goes on. And in response to this interrogatory response, the Gunbies listed a number of payments, correct?
Yes.
And those payments total $452,166, which I will scroll down. It's at the bottom of the second page. Do you see that?
I do.
And let me just object to the extent that that's what the payments actually total, because this is, again, hearsay, and there's a lot of conversions here with euros and Great British pounds. So I'm objecting to that's the number.
Okay.
Okay, well, one thing that would be helpful to me, Mr. Withers, just to make sure, is that page 4 and 5, right?
Yes, ma'am.
Of this D2, the table that straddles both of those pages, is Mr. Gunby's responses to discovery indicating the payments that his records indicated he had made, correct?
Correct.
And your point is between July of 2018 and April of 2024, Mr. Gunbie alleges that he made payments totaling $452,166. Is that right?
That's correct. And I have added those up myself to confirm that that's what those numbers add up to.
Okay, well, let's hope you went to math school better than I did, because I went to law school for a reason. But I have a calculator, and if I need to do the math, I can.
Yes, ma'am. Okay. Regardless of whether you contend that certain payments were toward the purchase price or for the repayment of other debts, between May 5th of 2018 and April of 2024, you acknowledged that you did receive $452,166 from the Gunbies, correct?
I received these payments, yes.
Now, but you contend that some of these payments were for things other than the purchase price of the property, right?
Yes.
But you don't know which of those payments you allege are for items other than the purchase price.
But you asked me before, so as you pointed out, the purchase price of the property was 450,000 plus interest. So it comes to like 501. Yeah. But during the term of the agreement, he only paid $114,416 during the term of the agreement.
Right.
Okay. So I'm not disputing that those, possibly because Mr. Gunbie himself said that these payments were for the property, prior loans and expenses in previous documents.
Okay.
Right. So what I will tell you is that then the sum. So do you want me to describe what these are for or not? Are you going to ask more questions?
Hang on. Sorry, Mr. Withers. I have one quick question. Is there any agreement, because I think that's what Mr. Badham was trying to get to. Is there any agreement that if you stop counting at some point in 2021, that number adds up to $114,416?
If you stop counting on June 30th, 2021, that's what that number comes up to.
Okay.
Okay. But my question, Mr. Badham, was you don't, regardless of timing, okay, as far as these payments, well, let's just put it this way. It's your contention that every payment he made to you after June 30th, 2021 had no relationship to the property whatsoever. Is that your position?
Yes.
Okay.
I think so, yeah.
Okay.
Now, yeah. Yeah.
I realize it's your position now. I understand that. Now, you contend that the purchase agreement was void in 2020 due to the Gunby's failure to make payments that were proposed in the agreement, correct?
Yes.
I'm not, just for the record, object, he didn't say 2020. It's 2021.
Okay.
No, I'm sorry, but.
Why don't you rephrase just so the record's clear?
Okay, so the record is clear. You said in an email.
You mean after the?
No, hang on.
Hang on. I can't follow, and I know the court reporter can't follow when y'all talk over each other. That's okay. Rephrase your question, Mr. Withers.
Right. Do you contend, well, let me ask you this. It is your position that the purchase agreement was void in 2020, not 2021, but in 2020, due to the Gunby's failure to make payments under the proposed agreement, correct?
Yes, because they didn't pay for 6 consecutive months.
Okay.
And the agreement canceled by its own terms.
Okay. So then, at least by your own testimony, some of that $114,000, let me see. So, well, I would draw that. And after 2021, or excuse me, in 2021, again, after you contend that the purchase agreement was void, you accepted a $9,000 payment in January of 2021, correct? And I'll scroll down here. Yeah, January of 2021, right?
Are you asking me a question?
Yes. My
Yes, I
question was, in 2021, after you contend that the purchase agreement was void, you accepted a payment of $9,000 in January of 2021, right?
Yes, I did.
And a payment of $9,500 in February of 2021, correct?
I did.
And a payment of $9,500 in March of 2021.
Yes, I did.
And you acknowledge that those payments were towards the purchase price of the property, right?
The property, prior loans and expenses, yeah.
I'm sorry?
Property, prior loans and expenses, as Mr. Gunbie has highlighted.
I'm going to ask you to flip to Exhibit 7 in your binder there. recall giving your deposition in this case, correct? And trying to,
What page are we talking about?
I'll get there.
7 is the one.
I'm sorry.
I've got 7.
I'm sorry, 8. Exhibit
Oh,
8 in your binder there.
Okay.
And at the deposition, you were placed under oath, correct?
Yes.
And you swore to tell the truth, correct?
Yes.
Okay. Now, I'm going to point your attention to page 65 of your deposition. And I'll pull it up here.
Are you talking about the pages in the boxes or the
The
pages are the numbers on the bottom?
Nope, the page is in the boxes.
Okay, 65. Right.
So this will be on page 17 of the transcript.
Got it.
Tell me when you're there.
Yeah, I've got it.
Okay. If you look at line 9, I asked you about the January payment of $9,000, correct?
Yep.
And in line 11, I asked you about the February payment, correct?
Yep.
And in line 13, I asked you about the $9,500 payment in March, right?
Yep.
And then in line 15, I said those were toward the purchase price of the property, right? And your answer was yes,
Yep.
correct? And then I followed up, I said, even though you contend that the agreement was void back in 2020, correct? So it is true that you accepted payments towards the purchase price of the property after you contend that the purchase agreement was void, correct?
I've never disputed that.
Okay, thank you.
I've never
Because just a
disputed.
minute ago, you said, well, it was for the purchase price and other debts, and that's not what you said.
Well,
No,
okay, but
let me finish my question,
Sorry.
please. Are you changing your testimony now from what you said in your deposition?
no, I'm not.
Okay, thank you.
Can you please clarify?
Sure.
He's absolutely allowed to.
Right.
Go ahead.
So at the beginning, when we discussed this and you saw the spreadsheet, then you saw that there was a number there that included the price of the property and the roll up of everything that we wanted to just tie off, and the Gumbies would settle their debts and we could go away separately and be friends. So when you ask me how much did they pay to the property, then it's in that context that I say, yes, they paid to the property. And I'm happy to say that they paid $114,416 to the property, if that's what you want. Now, the reason I accepted the payment too is they were friends. I still want him to buy the house. When I told him the agreement was void, I also said, hey, it's going to run out in June 21. That says, hey, get your act together, pay all the money, and we can solve the problem. All right, and you can own the house.
So you,
I don't think one disallows the other.
okay, so you accepted payments of at least $28,000 towards the house after you considered the purchase agreement to have been void, right? And then you received payments from the Gunbies after June 30th of 2021, right?
I did.
But you contend that none of those payments were towards the purchase price of the house.
No,
And just so the record is clear, no, you don't believe they were towards the purchase price of the house, or no, you don't agree with my question?
I don't believe that they were the purchase price of the house.
Okay. You contend that all of those payments were for amounts that he owed you for things other than the house?
Yeah, well, if you do the calculation,
Just
yeah,
yes or no? Was every payment that he made after June 30th, 2021 towards something other than the house?
yes,
Okay. But you don't know how much he owed you other than towards the purchase price of the property, do you, at that time?
he owed me 742,000, and then whatever the line item, whatever the total was in the spreadsheet, at whatever date you want to pick.
Okay, I'm going to show you your deposition again at page 59. Okay, if we look at page 59, I asked you, well, we start at the top. I said, you did receive payments from the Gunbies after June 30th, 2021. You said you did. And I said, at least some of those payments were the purchase price of the property. You say they were not for the property anymore. They were his debt. He owed me money. I said, okay, how much did he owe you as of June 30th, 2021? You say you would need some more information to calculate that, to tell you exactly what that was. So my question again is, do you know how much money he owed you other than toward the purchase price of the property as of June 30th, 2021?
$241,000.
Okay. Where does that number come from?
Right. That comes from the prior loans. So the money that he owed me before 2018.
Okay.
Right. Some adjustments for rent that we agreed. They're discussed in some of the emails that you've got in Discovery. The outstanding utilities and the flex payment.
Okay. So as of,
So you can arrive at that number, just to make it clear, you can arrive at that number by deducting 501,000 or whatever it is from the 742.
okay. So it's your testimony that as of June 30th, 2021, he owed you $241,000.
No, that's not my testimony. I am saying to you that I've said here that he owed me money. Then I couldn't have broken it down.
Okay. And I'm asking you, you just gave me the number $241,000?
Yeah.
So is that the amount that he owed you on June 30th of 2021?
Yes, he did.
Okay. Do you know how much money he paid you after June 30th, 2021?
245,000 up until Connaught.
Okay. So I'm not 100% sure I'm following all this, but you're saying that whatever he owed you after
Right.
June 30th, hold on, let me finish the question. You said that as of June 30th, 2021, he owed you $241,000, correct?
Yes.
And you,
Well, actually, not true, because he actually, at June 30th, he owed me the balloon payment. He owed the money for the house because it didn't end until, June 30th, right?
how much did he owe you as of, for things other than the property as of June 30th, 2021?
241,000.
And you said that after June 30th, 2021, he paid you $245,000?
Yes.
Okay, thank you.
Between then and, I think, March 22, I think.
And I'll just represent to you that at least according to my client's discovery responses, and I'm sure your counsel will cross-examine Mr. Gunbie on this, I will represent to you that at least according to this, and you said you received all these payments, my client paid you $337,705 after June 30th, 2021. In any event, you never rejected a single payment from the Gunbies after June 30th, 2021, did you?
So, sorry, you're saying that of all the money that I received after June 30th, that adds up to 337.
Yes, but my question to you was, you never rejected a single payment from the Gunbies after June 30th of 2021.
Well, I wouldn't, because he owed me the money.
And you never sent a written notice to Mr. Gunbie to the effect that you considered all of his payments after June 30th, 2021 to be toward debts aside from the purchase price of the property. You never notified him of that, did you?
Because the agreement had terminated.
And Mr. Gunbie did express a continuing interest after June 30th, 2021 to still purchase the property, correct?
We were still talking about that, yeah.
And when they moved into the property in 2013, You don't recall when the last time you were at the property before that date was, do you?
Between 2013.
When the Gunbies moved, before the Gunbies moved into the property in 2013, you don't know when the last time you were at the property before that was, do you?
No.
And you don't recall when you visited the property at all between 2010 and 2013, do you?
No, I don't really.
Okay. And you didn't make an inspection of the property at any point between the time that you agreed to allow the Gunbies to live there and the date they actually moved in?
No, I didn't. But my brother-in-law is an architect and I trusted him to tell me what was up with the property.
So you
if
have
there's
no,
anything wrong with it.
so you have no personal knowledge of the condition of the property at the time the Gunbies moved in, do you?
Honestly, I can't recall. I can't recall that. But in terms of when I last saw it, I can't remember when I last went there. I mean, that's a long time ago.
I just want to be clear. You can't say for sure exactly what the condition of the house was at the time the Gunbies moved in, right?
No, all I can tell you is that the people that were living there a few months before the Gunbies moved in had no issue with anything in the house.
So the answer is no, you don't have personal knowledge of the condition of the property at the time the Gunbies moved in.
I don't have knowledge because I've seen it, but I have personal knowledge because I was told.
Okay. I think we'll move on. You have no idea whether the pool mechanical system was functioning properly at that time, do you?
No.
You have no personal knowledge as to whether the HVAC system in the basement was functioning properly, do you?
No.
You're aware that the rear patio did not have, the rear patio is elevated, right?
Yes,
And you're aware that it did not have a fence or a guardrail, correct?
it did not.
At least at some, even notwithstanding that the language of the May 5th, 2018 purchase and sale agreement expressly references the word improvements, you at least later learned that they had made improvements to the property, correct?
In April 24, yes.
Okay. I'm going to ask you now to turn to interrogatory number 15 in Exhibit D2.
Can you tell me what, found it by accident, page 8.
Yes, Your Honor. Now, interrogatory number 15 asked the Gunbies to list all the improvements they made to the property, right?
Yes,
And in response, the Gunbies listed about 40 different repairs or renovations they made to the property, correct?
yes, they did.
Including the amounts of those repairs and renovations, right?
Yeah. I mean, to be honest, they split up jobs into component parts to make more, but yeah.
In any event, you have no basis to dispute that they made all of the improvements listed in response to this interrogatory, correct?
I haven't seen these things, so
Right.
I don't know whether they made them or not.
Okay, so you don't have a basis to dispute these improvements.
No,
Okay, and you have no basis to dispute that the amounts that they claim they paid for those repairs and improvements, correct?
no.
Okay. Now, Mr. Gunbie assisted you in locating some employment opportunities, correct?
He made some introductions, yes.
For example, to Ernst & Young in March of 2017, right?
Yes,
Which resulted in you obtaining consulting contract in the Middle East, right?
Yes.
And you were doing projects for Ernst & Young through 2020 or 2021, right?
Yes.
And you were paid for that consulting work, right?
Yes, I was by UI.
And you made more than $250,000 on those contracts, right?
Possibly.
He later offered you direct employment with his company, Connaught Services, right?
Yes, he did.
Which you started working in 2022, correct?
Yes.
You were the chief operating officer,
Mm-hmm.
and you held that position until 2024, right?
Yes.
And between 2017 and 2024, other than some rental income and your corporate pension, every other source of income you had was somehow derived through Mr. Gunbie, right?
It was derived through his introduction in the same way that you're here now because of your relationship with the BABG and Arnold Golden Gregory. I mean, that's how it's called networking. I mean, that's what happens.
Right. Well, and some of that was because you were working directly for his company, right?
From 20 to June 22, yeah.
All right. So, and your counsel is asking you about these wise transfers, and just, I guess so the trial record is clear. Wise is a cash transfer application or something like that, kind of like Venmo.
It's an online bank.
Okay.
It's an online bank.
Right. And I just wanted to make sure that
Yeah.
whoever's reading this, because before this case, I had never heard of Wise.
Yeah.
So,
And for the court reporter's benefit, it's spelled like the word, W-I-S-E.
thank you.
And
And
you might find references to TransferWise, which is what it was originally, and then it changed its name to Wise.
right. And the payments that were made through Wise, that even the payments from Connaught were made through Wise.
Yes.
Did you ever have a bank account in Bahrain?
No, I did not.
Okay. So that would explain why the payments were made through Wise, right?
Well, not necessarily. I mean, it was just easier.
Okay. I mean, you paid taxes on all those payments, right?
No, there is no tax in Bahrain.
Might need to consider moving to Bahrain.
You should.
At the time you secured those consulting contracts, the Gunbies were behind in payments to you, correct?
I'm sorry, at the time he secured,
The consulting contracts.
thank you, with EY?
Yes, ma'am.
Okay.
Correct.
Possibly. Yeah, I'm sure. I don't know. I would have to look at the spreadsheets, but I can't remember that far back.
During the time you worked for Mr. Gunbie at Connaught, he was also behind on the house payments then, right?
He wasn't making any house payments.
So then he was
Making
behind.
any house payments. So he wasn't behind. He just wasn't making any house payments because he didn't need to make a house payment because, you know, the agreement had terminated. As far as I was concerned, he was still living there and not paying me any money.
Other than the consulting contracts and working at Connaught, did you have any other earned income between 2014 and 2024?
2014.
I'm just gonna object on the relevance.
Yeah, I can't, honestly, man, I can't remember.
I'm gonna let him answer.
You never sent a notice of default to them
No, I didn't.
because you were dependent upon Mr. Gunbie for brokering those contracts and for employment at Connaught, and you didn't want to take any action that might interfere with the income stream that he was helping you acquire, right? Well, you contend that between 2013 and 2016, you made 16 loans to the Gunbies, correct?
Yes,
Okay. And those loans totaled $106,000.
yes.
And there's no written loan document for any of those loans, is there?
No,
And there's no promissory note that Mr. Gunbie signed for those loans, is there?
no,
And there's no written agreement regarding any payment terms for those loans, is there?
no.
And you said, I believe you said that Mr. Gunbie didn't tell Mrs. Gunbie about the loans, right?
That's what he told me.
Okay, so you're just relying on what he said. You have actually no knowledge as to whether or not she knew about them.
I don't have a relationship with Mrs. Gunbie, and she wasn't involved in the terms of the deal, so.
Does he have your exhibits up there?
No, there's no part.
Okay,
But here's one if you want.
well, yeah, let me do that. Okay. I'm sorry, may I approach?
Absolutely. And you don't need to ask. It's just us.
Okay, I would like you to turn, plaintiff's exhibit 2, if you would. And this is the spreadsheet that was admitted over objection. You created this spreadsheet, right?
Yeah.
So, and you said this reflects I believe you testified this reflected all the outstanding amounts.
Yeah, this is where I kept track of the utility payments and HVAC leases and pest control and everything that was there between us.
Right. And so you said Mr. Downs asked you about the flex, and you said it was a plug, correct?
Yeah.
And you said you just introduced that as a number to get you where the parties wanted to be?
Matthew introduced that.
Okay. Of this, so the starting number on this is $742,000.
Yep.
How much of that is flex?
Around 100.
So where can
91 or something.
where can we go? What document can we look at that shows all the other amounts other than that 91 that's a plug?
That would be on the spreadsheet that ran through from 2013 to 2018.
Okay, but is that
You have that?
Have we looked at it today in trial?
No.
Okay, so we're just going off that we just have a $742,000 starting number, right?
Yes.
With no documentation as to where that number comes from or what is included in that.
I mean, we don't have documentation for anything. This is an agreement between friends. That's the thing, isn't it?
Right, but you're asking.
So yes, we have the spreadsheet that came before where I tracked the utility payments, their rent, their loans, etc. before 2018. And then I created another spreadsheet to do the same moving forward from 2018.
You're saying that as of the beginning of this document, which looks like either June or July of 2018, that my client owed you $742,000, correct?
Yes.
And I want to know, where is the documentation for any of the numbers that make up that we've seen today?
You haven't seen it today.
Okay. And all these numbers in this spreadsheet, do you have any documents that back those up, such as, I mean, the utilities that you've listed here? Are there documents that I can look at to confirm that those numbers are accurate?
I'm afraid you can't go back to 2018 anymore. But you can go back as long as Georgia Power will allow you to go back, as long as Atlanta City will allow you to go back, and you would find that they match properly.
Okay. But have you done that? Did you print out those documents?
I didn't print them out when I produced the spreadsheet because I put those numbers in every month when I got the bill.
Hang on, let me clarify something, because you just used the word when I produced the spreadsheet. You mean when you created the spreadsheet?
Yeah, well, when I was managing the spreadsheet.
Forgive me, the reason I'm making that distinction is as opposed to when you produced it to the other side in discovery.
Well, in that sense, created the spreadsheet.
Thank you. Okay.
So what would happen? I would get the Georgia Power bill every month, as I'm sure you do, and then I would take that number and I would put it in the spreadsheet, and then I would pay the bill.
Okay, so there is some document out there, or there was at some point, that let's just take, for example, the utility, $495 on the July 18th column here. There's a document somewhere that would have said $495 for utility CRDR, whatever that is.
Yeah.
Okay.
Well, what does it say?
It says
Utility CI, no, there's a separate line item for, I can't see it in front of me, but there's a separate line item for electricity and water, isn't there?
Well, okay, what is utility?
Just tell me, just show it to me so I can see.
I just gave it to you.
And if I can, maybe save us some trouble, right? So I just have general walking around knowledge that if I needed to prove that I paid my power bill in 2013, it would take a great deal of effort, but it probably could be done either through Georgia Power or through my bank.
Sure.
And that your point is that had he wanted to, he could have provided those documents rather than just his testimony?
My point, and this goes to the objection that I had to this document, is that, he's saying that that my clients owe him the amounts that are on this spreadsheet.
Right.
And I'm saying, show me the documents that show that this number is accurate.
Right. And so the reason I interrupted is to say, I understand your point that the absence of documents, both from a practical perspective, an argumentative perspective, and a rules of evidence, if the jury was here, I would instruct them perspective, that if there are documents that would be better evidence, then that goes to the weight and credibility of this witness's testimony.
Right.
So you don't have to keep proving that he could have gotten those documents because I'm fully confident that he could have. It probably would have been a giant hassle, but might have been worth it. Who knows?
Right.
Go ahead.
I mean,
They're just not available.
right. And simply, Your Honor, and I'll move on after this. My point is, if you're going to say that my client owes you all this money that is based on all of these figures, it would be fair and reasonable for me to expect to verify instead of just taking on faith that all these numbers are accurate. It would be fair for me to want to look at that to confirm that what he says my client owes is accurate.
True, but not for nothing. For the better part of 5 or 6 years, your client never said, "Is that really right? Could you send me a copy of the bill?"
I understand.
And he could have done that too. So
Right.
that's how we all got where we are right now.
That's my point, Your Honor. Thank you. Okay. Now,
You were asking me about these line items. So,
right.
So the utility CRDR is not apparent. It's as I recall, it's 6 years ago. I can't tell you exactly what it is. It's some work that was done on the house that Matthew agreed to pay for. And that finishes. I think there are 3 entries on that from July to October. And then I don't think you'll find another entry under that column for as long as the thing exists. So, and then the electricity and water are quite clear, and they came directly off the bills. But you can't get September 2018 Georgia Power bill from Georgia Power because I tried.
Of the 16 loans that you made, 2 of those loans were actually to the Gunbie's sons, correct?
They were for the Gumbies to start a business, the Gumbies' sons to start a business.
Right. And those total $10,000.
Yes.
And you have not sued the Gunbie's sons in this case, correct?
No, I have not.
And some of the loans were for business expenses, right?
When? Prior to 2018, they weren't at all. Apart from the seed money for the valet business. And other than the valet business, I didn't lend Matthew money for business. I always gave him personal loans. What he used it for was up to him.
Okay. it's your testimony that none of the $106,000 in loans that you said you made were for business expenses, right?
No, because they were prior to 2018.
Okay.
And he was not borrowing. All these loans came in the early days of the relationship. I mean, 2013, 2014, 15, maybe 16, I don't know, but definitely not much later than that. Now, I did give him some personal loans in 2023, but they're not included in that number.
I'm sorry, you made some 4 personal loans to cover business expenses in 2023, right?
Yeah,
Okay.
Mr. Withers, forgive me.
sorry.
Can you clarify what, y'all have so much more context about
Sure.
depositions, et cetera, that I don't have. What do you mean when you say, I mean, he says he made personal loans, right? Why is it relevant that those personal loans were used for business expenses, and what business were the expenses for, and why is that relevant to my consideration?
Right, because I believe some of these loans, all this $742,000 that he says is owed. My point is that, a not insubstantial amount of that are not personal loans. I mean, for example, he said he made $106,000 in loans to the Gunbies, but he just said that he made that at least of that, 10,000 was to the Gunby sons.
Right?
Okay.
And I understand that, but my specific question is, you were asking him about some of the personal loans were for business expenses. And I'm asking, what business was it? And does it matter that he knew that it was going to be used for that purpose?
Right. That's a fair, I understand your question. And I'll withdraw it and I'll circle back a different way.
Thank you, sir.
That'll make it easier. You claim that you effectively loaned Matthew Gunby's company, Connaught Services, $296,348,000 in foregone salary and unpaid expense reimbursements, right?
Yes.
But you have not sued Mr. Gunby's company, Connaught Services, have you?
No, I have not.
Okay. But you contend that Mr. Gunby is personally liable to repay those loans, those effective loans that you made to Connaught Services, right?
I think what I said was that he has an obligation to settle his debts. And since our relationship in 2013, he hasn't been very good at doing that. So I would like him to settle those debts, right? Now, maybe the deferred salary, right? I'll be very upfront and open. The deferred salary was my choice, right? Okay. But I was paying expenses and the salaries of staff when Matthew wasn't even in the country. And I expect those to be reimbursed. And I think there's some honor that needs to go there. But am I going to chase him for it? No, I'm not.
Okay, but my question is the $296,000. Those are amounts that Connaught owes you, right?
Yes.
But you contend that Mr. Gunby is personally responsible to repay those loans to you, correct?
Your Honor, I mean, we're not seeking money.
Yeah, we're not asking for any.
Sorry, there's an objection pending, so you gotta let your lawyer make the objection for you. Go ahead,
Just
sir.
in the interest of speeding things along, we're not seeking money. Whether Mr. Gumby's personally liable, I don't see the relevance.
Okay, the
I
relevant.
think I understand Mr. Withers' point. Whether it proves ultimately to be relevant to the court's decision-making is an open question, but I see the point he's trying to make, and so I'm gonna let him try to make it. So keep going.
And the point I'm trying to make, Your Honor.
So overruled. Go ahead.
The point I'm trying to make is that when we get down to the end of this case, we're talking about math problems here, at least in some extent. When we talk about
Is this a question?
No.
It's not. Well, here, I'll tell you, you can stop selling because I've already bought, right? I overruled his objection and said you could continue with that line of questioning. So go ahead.
of that $106,000 in loans, that we talked about, the 16 loans, how much, you can't tell the court how much Mr. Gunbie has repaid of that, can you?
I think he repaid it's on the spreadsheet. I think he repaid everything apart from maybe 30, 40,000.
So it's your testimony then that the total amount that he owes you still in outstanding loans is, or at least for those loans, is $30,000 or $40,000?
No.
What is the outstanding balance of
Okay.
the loans, of those 16 loans that you made?
Right. I can't tell you accurately,
Okay.
but if I can explain, can I explain?
Yes,
And
sir.
just clarify this. So, as I've stated previously, that the $742,000 that we started with in 2018 was designed to put together everything that was outstanding for us.
Plus
Including the
cost of the
house.
house.
Yeah.
Okay.
So going back before then is pointless because we've agreed that that's the starting number. And that number was agreed between me and Matthew.
Okay, well, it's on a spreadsheet that you created, right?
Okay, that Matthew had every month and never objected to.
Okay, well,
And it may become a dispute, but so far, Mr. Badham has testified multiple times that this was an agreement he had with Mr. Gunbie. And I'll hear from Mr. Gunbie whether or not he agrees.
now, in October of 2023, the Gunbies were still behind on payments towards purchase of the property, right?
Okay, no, they weren't.
Okay.
They were behind on payments for expenses and utility bills. They weren't giving me a penny, even though I was paying the mortgage and all the expenses of the house.
Okay. Turn to exhibit, and I'll put it up here, D3. You recognize this document.
Yes, I do.
This is an October 16th, 2023 email from you to Mr. Gunbie,
Yep.
and it concerned a new proposed agreement for the Gunby's purchase of the Colwood property.
Yep.
And you wrote that you were attaching a new draft sales agreement.
Yes.
And you wrote, I settled at the price at the median, I settled the price at the median Zillow price
Yep.
at the weekend, which will certainly give you value for the improvements you have made.
Mm-hmm.
So at least as of October of 2023, you recognized that the Gunbys had made improvements to the property, right?
Only the roof and the retaining wall. I knew nothing of anything else.
And you certainly recognized that those improvements had added value to the property, right?
No.
Well, what you said was, which will certainly give you value for the improvements that you have made.
Right. So you spent money on the property, you'll get some value for that.
You said if this
Right?
doesn't,
Because I could have not settled on the median Zillow price. I could have settled on the highest Zillow price.
Okay.
But I was giving them an option, to say, if we do this, then if you're going to have some, say, if that's the median Zillow price, then the range was probably, what did I say, 750, whatever it was. So the range was probably 690 to 850, right? So if you buy a house at 750, but you can argue that it's already worth 850, you've got some value, yeah?
you said if this doesn't work, you can move on to a rental agreement with a right of first refusal or an option to purchase for 3 years, right?
Yes.
So at the time you sent this, the Gunbys were not on a rental agreement, were
No,
they?
they were not.
And you never provided a rental agreement, did you?
Nope.
And and I believe this was previously marked as well, but by your counsel, but I'm going to if you take a look at Exhibit D4, which is the draft, the October 14th, 2023 heads of agreement. And again, you prepared this document, right?
I did.
And it provides for a purchase price of $764,000, right? And this is
I'm
the
sorry,
number.
is that a yes?
Yes, it is.
Thank you.
Sorry, I'm forgetting my yeses.
That's okay.
And you got this number from Zillow, right?
I got that number what?
From Zillow.
Yes.
And I guess, so the record is clear. I think maybe Your Honor may have asked it when he was on direct, but Zillow is a website that lists homes for sale and also provides what it considers to be the market value of houses, even if they're not on the market, right?
Yeah, it's a range.
I think they call it a Zestimate,
Yes, Your Honor.
but I'm very familiar with Zillow.
Yes. And I know, I'm sure the court is, but I don't know who else might be reading this transcript.
Absolutely understand, Mr. Withers.
So, okay, so that as of the date of this document, Zillow had presumably listed the value of the Coalwood property as $764,000,
Is that a yes? Thank you.
which, and you understood that to be in the middle of the range of the fair market value of the property, right?
Yes.
Out of curiosity, do you know what the value of the home is according to Zillow today, or the Zestimate today?
No, I did.
Okay, well, I'll represent to you that at least as of 2 days ago, it was $820,900. But in any event, in 2018, the purchase and sale agreement that we looked at, Exhibit D1, the parties agreed on a purchase price of $450,000 for the property, right?
Yes.
So would you agree that between 2018 and 2023, the property increased in value from $450,000 to $764,000?
Yes.
And you have no idea one way or the other whether any of that increased value was due to the improvements that the Gunbies made at the property, do you?
No.
The parties never executed this agreement, Exhibit D4, did they?
No.
Now, I believe you testified earlier, and please correct me if I'm wrong, because I just didn't write it down, but I think you said that from October of 2023 through April of 2024, you had some discussions with Mr. Gunbie about the possibility that you needed to sell the Coalwood property. Do you recall that?
Okay, so what I said was, and this is the reason for this, is that the business wasn't doing very well. Like I said, I wasn't getting paid. The reimbursements were coming sporadically. And so we were talking as friends at this point, about, hey, I've got some problems here, right? Because I'm running out of money. I can't carry on subsidizing your family in Coalwood Court. I'm going to have to make some decisions. I'm going to either have to put some debt into a condo that I have in Midtown, but that's really hard because I don't have I can't produce US tax returns, which would get you a mortgage. Or I'm going to have to sell it. Now, I said, if I sell the condo, then I'm going to have to sell the house because I can't leave you in the house for free, right? And me having to sell another property is just not right.
So at least as early as October of 2023, you knew there was a possibility that you might need to ask the Gunbies to move out of the property, right?
Yes, and I was very upfront with Matthew about that.
You didn't tell him at that time you needed him to move out, did you?
No, I didn't.
And then you met with Mr. Gunbie at the Coalwood property on April 12th of 2024, right?
Yes.
And you told him you needed to sign some documents at that time, right?
Well, because I managed to find an asset-backed loan to take out a mortgage on the previously paid off condo that would use the rent, because we rent that. So they would use the rental income to pay the mortgage,
And-
to originate the mortgage.
Right. And you needed Mr. Gunbie to witness your signature, right?
Yeah, well, I didn't need Matthew to witness my signature. What they wanted me to sign the document in my main residence, which has always been listed as Colwood Court.
Sorry, you
And
said,
so I asked Matthew to do that.
well, you told him you needed him to witness. The reason you came to the property is because you needed him to witness your signature, right?
Oh, okay, I could have asked, somebody else to come to the property. It was the property that needed to witness the signature, not the person. But Matthew was in the property and he was my friend, and I said, "Can you witness?" And he said yes.
I apologize. When was this?
April 2024.
Okay, I thought there had been testimony earlier that Mr. Badham hadn't been to that property and hadn't seen it and had no knowledge of its condition.
That was in 2013.
Thank you for the clarification. I appreciate it.
Okay, well, this is new information that you didn't share during your.
I think I did.
In your deposition?
I think I shared it with you before.
No, I'm sorry, the point about that, the reason you went to the property was because they wanted you to sign a document while you were physically located in your main residence.
Is that a yes?
Yeah, that's a yes. Yeah,
Okay.
that's what they asked me to do because it's just the nature of the rules, I guess.
Okay. Anyway, you saw Mrs. Gunbie at the house that day
Yes, I did.
and you had a conversation with her
Yeah.
and she told you she was thinking about replacing the kitchen.
Yes.
And you didn't say anything to her about the fact that you would need to move back into the property and that she would need to move out.
Well, one, it wasn't decided then. And two, Matthew had requested since he started borrowing money from us that she was not to be told about things like that.
When you first approached them about moving out, you said it would be just for 3 years, right?
No, I didn't say that. I said our son needs to go to high school for 3 years and then possibly we'll move back to Europe. And then, whatever the price is for the house, then maybe you can have the right of first refusal. I mean, that was it. These are conversations amongst friends who are trying to make this thing palatable.
So is it your testimony that you did not tell them that, hey, we'll just move in for 3 years and then after my son graduates high school, we'll move out and you can move back in?
No, I didn't say that.
Okay.
And not so concretely. We said, he's got to be in school for 3 years. Maybe we'll move back to Europe. And that's what it was, because who knows what happens in a year, let alone 3 years.
The reason that you wanted to move back was because your son wanted to lessen the intensity of his tennis regimen, right?
Okay, that was one reason. That was one reason. The other reason was that we had no money, and that was more pressing.
At no point in time, again, I think we've established this, but at no point did you ever send a default notice, right?
No,
Never, up until this lawsuit or till April of 2024, never demanded that they vacate the property, right?
up until we asked them to leave in
Right.
April.
Through all the missed payments and the unpaid loans, right? And never was there before, well, I guess, for the initiation of this lawsuit or this dispossessory proceeding, never demanded that they vacate the property. And there was never any written document terminating the purchase and sale agreement, right?
No.
If you'll look at Exhibit 5.
Are you putting it on the screen or do you want me to?
Oh, I'm
put something
sorry.
here?
Okay. So Your Honor, we already admitted this one.
I believe that D5 was on the list of things that Mr. Downs did not object to, but I don't know that it's been offered by anyone yet.
It is actually,
Is it P something?
It may,
Okay.
I just wanted, my question is, do I need to authenticate?
Better to have it in twice than to not have it in at all. Mr. Downs has indicated that he thinks it was already admitted, but either way, Mr. Downs has already indicated he has no objection to your admission of D5.
That was my question. Okay, thank you. So this, again, this is an email that you sent to Mr. Gunbie on December 30th of 2020, right?
Yes.
And you said in the second line, you said there have been no payments for 20 months and the agreement, technically void at the moment, is due to end in June 2021. Do you see that?
Yes.
And to be clear, you continue to accept the payments from the Gunbies toward the purchase price of the house after you sent this email, right?
Yes.
And in fact, you did not treat the purchase and sale agreement as having been terminated, correct?
Well, I think both things are different. I assumed that I guess what I had in my head, and bear in mind, I'm not a lawyer and, I'm not a commercial real estate investor. And I wanted Matthew to buy the house and to complete the purchase.
Thank you.
So, right. Yeah.
If we look at Exhibit D6, I believe this was previously admitted. We look at the initial email in this chain, which is is on page 2 of this document. You see where you wrote, "Good morning, you better have this." You said you wanted to catch up the Coldwood position.
Yep.
So with the payments you made to me in August, the current state is, and then it goes on. Do you see that?
Yeah.
So this is in September of 2022, right?
Yep.
And Mr. Gunbie had made payments to you toward the Coldwood position as recently as August of 2022, right?
He paid for some utilities, yeah.
How much did he pay in utilities?
I think 15,000.
And that was the amount, what was the amount of the utilities owed at that time?
Probably 40,000.
Yeah, but we don't have any documents that show that, right?
You have my spreadsheet.
Right. Okay, so then you said, Mr. Gunbie responded to you on the next day on September 10th, 2022, right? Let me go back to this $15,000 payment. You said it was for utilities. Did Mr. Gunbie tell you that it was for utilities? Or is that just how you elected to apply it?
No, I think he said I think he sent me some sort of WhatsApp saying I'm sending you money for the utilities or the house costs or something like that.
What was it, the utilities or was it the house cost?
Yeah, but the house costs, the house expenses. I mean, that's what it means.
So you testified that it was for utilities. I'm trying to.
Okay, what are the costs of the house? So, no, he didn't say it's for the electricity, it's for the water, it's for the pest control. He said it's for the cost because all he's paying me for now is expenses. All I'm asking for is, hey, pay me the expenses of the house because I'm paying all your bills.
Okay, so if Mr. Gunbie testifies that all these payments that he made after June 30th, 2021, that he thought he was paying towards the $450,000 purchase price, you obviously disagree with that.
Yeah.
Okay. Then on September 10th, 2022, you responded back to Mr. Gunbie. This is at the kind of on the bottom, well, kind of right in the middle of the first page of Exhibit D6. And you wrote,
I can't see it.
sorry, it's in the binder there in front of you.
Where is it in the binder?
Exhibit D6. But in any event, I'll put it on the screen for you. Okay. So in the second paragraph of your September 10th, 2022 email, you wrote, I misunderstood you about the catch up for Colwood. I mentioned that as the deal did not end in July 21st, 2021, I was still carrying the monthly mortgage, tax, and insurance when I anticipated this would be gone. This represents $2,172 per month. Utility bills run around $600 a month. In addition to this is my rationale for the numbers. Do you see that?
Yes, I do.
So again, in September of 2022, you have expressly told Mr. Gunbie that the May 5th, 2018 purchase agreement did not end on July 1st, 2021. That's what you said, right?
No, that's not what I said.
That is, okay, what you said was,
So let me save you some trouble. I don't think he's saying that he didn't say the words that are on that page, that he didn't send that email.
Yeah.
Feel free to have a conversation with him about what.
sure. You came up with an explanation earlier today about what it was that you meant by that, right?
Yes.
And that is not what you said during your deposition, was it?
In relation to this, I think it is. You know,
Okay. You testified that the rental value of the property is $5,000 a month?
possibly.
Possibly. Okay. And that's what you got from Zillow, right?
Well, yeah, part of that, yeah. Zillow and other sites, and I took a ballpark. Yeah.
Okay.
Ultimately, it's going to be whatever somebody would pay. But that's what similar properties are going for.
Do you have any documentation that shows where you got that number, or would we just have to look at Zillow?
You just have to look at Zillow.
If we go back to Exhibit D1, Section 2.6 says, if the seller wishes to cancel this agreement, notice must be provided in writing. All payments made by the buyer prior to the notice of cancellation will be due back to the buyer within 90 days of such written notice. Do you see that?
I do.
And you contend that the purchase and sale agreement terminated by its own terms before June 30th, 2021, because the Gunbies had failed to make certain payments, right?
Yeah, they hadn't made 20 payments.
But you later told Mr. Gunbie in writing that the agreement did not terminate, right?
No, I didn't say that at all.
That's not what it says.
Okay.
So I can read and I see what it says, and it appears clear to me that the parties have different understandings of what those words meant,
Right.
but the words are there.
Right.
The termination isn't there in
Right.
the email.
I want to go back to your deposition. Bear with me, I'm having mouse troubles here. Okay, I understand that we have a difference of interpretation as to what you meant when you said the agreement didn't end, but I just want to go look at your testimony in deposition. And you see on page 144,
Yeah.
it says, I said, you never canceled the PSA, correct? And you said, well, the PSA canceled. The PSA canceled itself because he didn't make any payments under the PSA. He didn't make the right number of payments. Yeah. And I said, yeah. Then you later stated that it did not terminate in 2021, right? Your answer was yeah, correct?
Yeah,
Okay.
I saw that. And
So-
I would like you to show me where I stated that.
That's,
Because I think you mischaracterized what I was saying about the end of deal sentence.
I'm just reading the questions. Then
I mean, it's very clear. It says that I stated that it did not terminate, and I don't think I did state that at all. And in my head,
later,
we're carrying on a discussion about the end of deal.
Mr. Withers, can you direct me to the page that you're reading
Yes.
from in the depot?
I'm sorry, it's page 144.
I think you said it. I just didn't get there fast enough.
No, I'm sorry, 144.
Go ahead, Mr. Withers.
Yeah, I just want to make sure that I'm reading our conversation correctly. And I said, and this is on line 8, then later you stated that it did not terminate in 2021, right? And your answer was yeah.
Yeah, but
Thank you.
remember, at this point, you were shouting very loudly. You were swinging the agreement around your head like you were going to lasso a steer. And, you know, I don't think I ever said that. And in my head, we're still talking about the email where I say the deal didn't end. And that's what the discussion is about. And I think you conflated the two things. And I think you mischaracterized deliberately what I said in order to get your little gotcha moment. Right? I mean, that's it.
All right.
Hang on. I apologize, Mr. Withers, but did you say page 141?
144.
Thank you. Because I'm rereading 141 and it's not there. Thank
It's on
you.
144.
Thank you, sir. Mr. Withers, sorry for the interruption. Go ahead.
No problem. I'm sorry. Mr. Badham, is it your testimony I was yelling at you during your deposition
Absolutely.
and I was swinging the agreement around like I was roping a steer?
Don't you remember that?
No.
Oh. There was no video of that deposition, but it was quite funny.
Sometimes I wonder if we were at the same deposition. In any event, you never refunded any of the payments the Gunbies made, did you?
No,
And you've never reimbursed the Gunbies for any of the improvements that they made to the property, have you?
no,
And if this court rules that you and your wife are entitled to resume occupying the property, you would, of course, enjoy the benefits of those improvements, right?
as they've enjoyed the benefit of living in a subsidized house for the last 13 years.
So if you could just answer the question, that would be great.
But we would live there, yes.
And you would enjoy the benefits of all the improvements they've made to the
I
house.
don't know because I don't know what the improvements are in the main.
You might not enjoy them. Right? So
Right,
keep going.
fair enough. You would have the ability to use the improvements, whether you enjoyed them or not, you'd have the ability to use them, right?
That has got to be true.
If the court rules that you and your wife are entitled to resume occupying the property, but that you have to refund payments that the Gunbies made towards the purchase price, you believe you're in a financial position to be able to do that, correct?
Yes.
Objective form.
I feel like I'm going to sustain the objection primarily because the parties' respective financial positions isn't relevant to the court's decision. I can enter a judgment for $1 billion and whether they can pay it or not really doesn't matter.
Okay, fair enough. Your Honor, that's all the questions I have at this time.
Okay. I have a couple of questions, and typically when I do a bench trial, what my typical practice is I'll ask a few questions, and then to the extent those questions messed up y'all's examinations, you're free to follow up or any other follow-up that you wish. But in this case, I think what I'm going to do is ask a few questions, and I'll throw it over to y'all, and then we'll probably take a quick break before we move on to the next witness.
Can I retake my position there, or do you?
Oh, no, absolutely. Go
stay
ahead.
here? Thank you.
Feel free to have a seat. And I don't have many questions. I do think one thing, Mr. Badham, that I am a little confused about, and I asked you right before we broke for lunch about the fact that your spreadsheet continues to credit payments that are being made for Mr. Gunbie against this total $742,000 debt. Is that fair?
On its face.
Okay.
Yes, yeah.
And is it accurate that the reason you were doing that, it seems to me from your testimony that you were treating this as a global sum that was owed to you, of which the house was a part.
Yeah, at the start it was, yeah.
Okay.
And then I just didn't, it's full of formulas. So then I was using it to track the payments for utilities. Then I was using it to track the expense payments. Then I was using it to track the loan repayments, things like that. But the formulas just recalculate as if the whole sum is there.
Right.
So,
Okay. And you mentioned when you were working with Connaught, I heard you testify there were salary forbearances. You might have used a different phrase.
deferred.
Thank you. Deferred salary payments or deferred reimbursement for payment advances that you made to keep the business interests going. Is that accurate?
Yeah. That's
And were those, I guess I'm a little confused as to how it seems from some of the emails, well, it seems from your spreadsheet and also from some of Mr. Gunby's emails that both of you were treating some of those monthly payments coming from Connaught as crediting against other things besides your work for Connaught.
I wasn't.
Okay.
So they were very clearly for Connaught.
But the reason I'm confused is you credited them
No, they're
on
not.
that spreadsheet. They're on.
Didn't.
No, you didn't.
No, those
Okay.
payments are not on the spreadsheet.
I see. Okay.
Right. Only honestly through 24, 23, 22, 23, 24, the only payments that are on the only things that are on the spreadsheet are utility costs. And if you made some payments towards utilities or something, then I would put those on. And then post the, so I mean, that's really what it was. But the Connaught numbers are not on that spreadsheet.
Okay. And then the next question, I think it might be the only other question I have for you, but on Defense 4, which is the new proposed agreement that you communicated in October of 23, you start off with a dollar figure of $764,000. And then there's discussion of a down payment. Can you help me understand how it was that you came to that dollar figure and what you were or were not accounting for the prior payments that had been made under the old agreement?
Right. I wasn't accounting for any prior payments.
Okay.
Not at all.
Okay.
And I arrived at that number, one, the sales price, because it came from Zillow.
Right, sure.
And then two, Matthew and I were trying to generate business. And if I'd have said to him, you need to pay $12,000 a month, he wouldn't have been able to do it. So, but I wanted the costs of the house covered because I was being choked with covering their costs for 2 years without their participation.
And hang on,
Yeah.
forgive me for interrupting you, but to go back to a disagreement you and Mr. Withers had a moment ago, here, when you're saying costs, you mean the cost to maintain the property.
No, that's so
Minimum
having
mortgage.
there is the mortgage,
Right, the minimum-
utilities, everything that I was outlaying.
That's what I was clarifying, is that what you mean when you say that is, in this agreement, you were hoping to at least cover the
At
cost
least
of
cover the cost.
maintaining.
And then
Hang on, we can't talk over each other either. I
Sorry.
apologize, because she'll get mad at us. She can't take it down.
it's all right. I get excited.
That's okay. But just in this one context, what you mean when you just said costs was you were hoping out of this agreement to at least get a payment that would cover the outlays you were
Minimum
making.
costs, yeah.
Okay. Okay.
That's right. And then with the balloon payments at the end, we would hope, right? And we both hoped that the business would, be in such a place where that would be facilitated. That was the idea, but that would allow, the payment schedule, the $70,000, because I needed that to live, and what have you, would have paid something, but he didn't have the money for that either. So, it was moot, really. We were trying our best, but we were not being so successful.
Last question. You were asked, and it's a really minor point, you were asked about some improvements that the Gunbies indicate they made to the property. And I think you were asked about like a hot water heater and maybe a few other things you said you didn't know about.
No, the heater I did.
Okay.
The reason I knew about the heater, the HVAC and the water heater, is that at first they didn't tell me they wanted to do this.
Right, and that was the HVAC was really what I was getting
Right, okay,
to.
so the HVAC.
Okay.
So, and the HVAC and the water heater together, really.
Okay,
So just like all the other work that they did there, apart from the roof and the retaining wall, they never told me about it. They didn't mention it. They went and picked a water heater and a HVAC system. But actually, I might be right. I think they said we would like to replace the HVAC. I think they may have said that to me.
well, let me interrupt. The reason I'm asking the question is because some of the utilities you list historically throughout your agreement include this aircon lease thing, and I'm not sure I understand what that is.
Okay, so I'll explain. So what happened was they wanted to replace the aircon. Now, I would just replace the aircon with what was there before. They wanted a bigger system, I guess. I'm not really familiar with it.
And also, sorry, brief interruption, just to make sure we're not having a confusion because of British English and American English. When you say aircon, just a moment ago, you were referring to HVAC. Those are the same things to you, right? Because they're the same
They're
things to me.
absolutely the same thing to me.
Okay, making sure.
So just anything that provides hot and cold air and water, right? So that's what we're talking about. So they wanted a much bigger system. But Matthew said, I can't afford to buy it. I need to lease it. They're providing, the willing, reliable, I think it was, are willing to lease this. But they won't lease to me
Because he's a renter.
He's a renter. He doesn't own the property. So I contacted Reliable. I organized the building permit. And bear in mind, nothing else they did was permitted. But I organized the building permit for the HVAC. And then they did the work.
Okay.
And that was under a lease, which I had to pay for. And I continue to pay for that.
Okay.
Now, the initial agreement when that came was that the Gunbies were going to pay for it.
Sure.
But they never did that either. So, that stays with the house. So I guess, whatever.
Okay.
Yeah. So now I only really think about the electricity and water and things like that as something that they should reimburse for.
Okay, thank you, sir. I appreciate that. Those were all of my questions. Mr. Downs, did you have redirect or any follow-up on those questions?
I don't, Judge. I don't think I have anything.
Okay, any follow-up on my questions, Mr. Withers?
No, Your Honor.
Okay. So, Mr. Badham, you are free to step down. It is 3:26. I'm going to take a break until 3:45, and then we'll come back and keep on plugging along, okay?
Okay.
Thank you.
Thanks.
You can leave those up there.
Oh, I don't. Okay, you don't need it back.
Yeah, he might want them for another witness.
Okay, got it.
All time without a break.
Court will be open during this break, or will it be locked?
Okay.
I need to thought
Question, is she still deciding on one, two,
You said.
I can't, I was waiting for her kid.
I think. So,
I think we're still.
Okay,
Because I know we were still going over
right,
that.
two, I believe she said that she would admit them in part.
Okay,
Um.
Okay.
So.
and I just want to
let's
verify
just
that
ask them.
address and
6365
Coal World,
Coalwood,
Coalwood, excuse me.
all one word,
Got it. Okay, I got that.
and
then.
it's 6365.
Yeah, I just did that first.
Oh, sorry.
No, you're good.
And then Connaught is,
Yeah, it's somewhere here.
I'll tell you what, I know.
I could have just looked in the document.
No,
I had
no,
it
it's
there.
CONNAUGHT services.
AUGHT, okay. Thank you. Yeah, I was looking up, but I was like, I want to just double check.
Yeah.
Okay. Thank you.
Thanks.
No problem.
Did I do? Okay, I need to stretch my legs a bit.
I'm coming.
Oh, yeah, take your time. I didn't know if you heard me.
Sorry, I snuck back in. I'm a couple of minutes early anyway, so.
No. You're allowed to do whatever you want.
I was speaking at a panel for women lawyers, and always there's discussion about work-life balance, which of course now we refer to as, apparently I'm told, work-life integration.
Oh, God.
It sounds like HR speak, but I made the comment, because it was about women leadership and all the women on the panel were judges. And I was like, well, here's something. If you aspire to be a judge, here's a really good reason. At the end of the day, it's really easy to balance your obligations because you control everybody else's schedule. So.
Yeah. That's right. It's so funny with the like the Zoom layout. Like I was saying, everyone can see everybody. I was telling them before that before Zoom, my aunt was a judge here, Judge Downs.
Oh, I love Judge Downs.
Yeah, and during one of her trials, that was on TV. My grandma called in and made the clerk or the bailiff move the water bottle because it was blocking my aunt.
So true story. My mother, a lawyer's whatever, but once Zoom happened, she was like, I want to see you in the courtroom. And so similarly, she wanted to watch Zoom. So I gave her the Zoom and my sister got it all set up on the computer. And she called me when it was over and she said, oh, sweetie, you sound so smart. Also, you need to get your roots done. Yeah. Thanks, Mom. That's what moms are for. Right?
That's what they know.
That's right. That's what moms are for. Oh, goodness. But yes, Judge Downs actually, I've told her this. Judge Downs gave me my first, smackdown summary judgment motion. I was a civil defense attorney and I filed a summary judgment motion that I thought really had some merit, but it's always close. And we walked into the courtroom and she was like, yep, you get summary judgment. I mean, I walked out like I was the second coming. It was awesome. I was very excited. It was a good day for a young associate.
That's my aunt. Yeah.
Oh, okay.
It was a really good day for a young associate. So
you take the wins when you can get it. Yeah.
Exactly. Okay. So we are back on the record, Madam Court Reporter. And Mr. Downs, you may call your next witness.
One question, Your Honor.
Yes, sir.
Quick, I believe the court reporter, I don't know if she addressed it with you, but we had a question about the exhibits. And I believe your ruling on exhibit 2 was that you were going to admit it for limited purposes. So
it was, what I said, I think was conditionally admitted. It's now fully admitted except it's not the whole exhibit. It's the portions of the exhibit that you referenced. And then to the extent you need the cover page and the signature page to make it complete,
Okay.
et cetera. That was my ruling.
You know, and that's fine. My understanding was that we didn't, you know, to the extent I misunderstood you, you know, as to the stuff that was not disputed, are those in evidence now? Do I need to formally move to have those put in evidence? Or it's kind of my understanding that if it wasn't objected to and we started discussing it, that's in evidence.
So the only ones that I'm aware of that were an open issue, right, were D2, which we're discussing now, and then D8 and 9.
Right.
D8 was Mr. Badham's deposition, and you've directed me to testimony that you believe impeaches his prior testimony, and
Right.
and that's in. And then as to the discovery responses, the response to interrogatory number 8, which is multiple pages. And then there was one other interrogatory, and I don't remember which one it was. 15. Yes, thank you, which also is an answer that spans multiple pages. Those were the ones that I had written down. And those were the ones that, to my understanding, are admitted because we've discussed them and I allowed them. But the rest of them, unless you call my attention to a different portion of, I don't intend to consider in my deliberations.
That's fine. And just so the record is clear, to the extent, you know, I moved to admit all of the exhibits that I use subject to the court's, you know, statement that you know, on 2 and 8, I will only consider these portions.
That's correct.
Thank you.
Yes, sir. But otherwise, your exhibits are admitted
Thank you.
with the limitations I've just outlined. Yes, sir.
Yeah, the only thing I would ask is, or query about is his deposition transcript. I mean, I understand Mr. Withers impeached him with specific pages, but the whole document is admitted into evidence?
No, what I just said is he's directed me to portions of it that he believed impeached Mr. Badham's testimony.
Those portions.
And I'm going to consider those portions.
Okay.
And that's what I believe to have been admitted, not the deposition in its entirety and not the interrogatory and request for production responses in their entirety.
Yes, Your Honor, that's my understanding as well.
Okay. And technically, because Ms. Badham has not taken the stand, her deposition isn't yet in evidence at all.
Understood.
Okay. Mr. Downs, did that address your concern, sir?
Yeah.
And Mr. Withers as well?
Yes, ma'am.
Okay, you may call your next witness.
Without further ado, I'll call Ms. Badham.
Okay. You're fine, Deputy. Come on up, Ms. Badham, and I'll give you the same instruction. Please be cautious about when you sit down. Get situated at the microphone and make sure to keep your chair away from that ledge, okay? Once you get before you get sat down, will you raise your right hand? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, ma'am. Now, if you will get situated and scoot up to the microphone, and then if you will start by stating and spelling your name for the record, okay?
Okay. My name is Liliana, Liliana, Del Rio, Delrio, Badham, so hyphen Badham.
Okay, thank you. I'm sorry, Mr. Downs, you may proceed.
All right, Ms. Elrio Badham, good afternoon. Just a few questions for you. You personally reached out to the Gumbies about vacating Cold, correct?
I did.
Okay, and do you recall when that was?
It was in May of 2024.
And how did you reach out to them?
I first I called Kim, well, Yvette, so we know her by Kim, using WhatsApp, and I asked her for her email address, which she gave me, and then I sent her an email.
Show you the email that you're referencing?
Yes.
Is what's marked as plaintiff's 11 This is the email that you sent to Ms. Gunbie?
Yes, because I had first recorded a message, I remember now, and then I sent her this email.
Okay. And what was the purpose of sending this email?
The purpose was that, well, I was getting really stressed that we didn't receive any news from Matthew about when they were going to move out of the house. And we were, like Keith explained before, not only were we paying our rent in Spain and paying all the expenses and the mortgage of the house in Colwood Court, we were also paying tuition for our son to be in an international school. So I found it pressing to come to the US where I could go back to the hospital and get employed again, and Felix could go to school tuition free because we are entitled to, that school district, having been there, and having had that address as our address for so many years. And I needed the house in time for Felix to start school. And Matthew had gone back and forth saying that, yeah, I'm going to talk to Kim about it. And I said to Keith, okay, I'm really tired of this because this is very stressful. Because he had instructed us the whole time of our friendship, well, during this time when we loaned them money and let them use the house, and then, they lived there and then tried to buy it. One thing we had been strictly cautioned about was talking to Kim about any money matters, because she was very anxious about money and she could get sick. And anyway, so at this point, I just said to Keith, if Matthew doesn't say anything to you about when they're going to leave the house by a certain date, and I can't remember what date I told him, I'm going to just write to Kim and tell her what's going on. And so I remember that it was like we were in Barcelona. I had a little girls' trip to Sevilla with my friends, and the date came when I was sitting with my friends, and I said, okay, I've got to write this email because the date is today. And I wrote her this message, which was to inform her that, maybe you're not aware of what's going on, but we really need to get back to the US so that Felix can start school, and we need the house. And, it's been a long time. You've enjoyed the house for 11 years. All your grown sons, because when they moved into the house, they didn't have any minors. They were all, I think maybe one was 17, but everybody else was grown men. You enjoyed the house with your boys for this time. They all now have jobs. They've gone on to get married. So is it fair for us to move back to our home that we're paying for, was the subtext. And, Felix can enjoy it and finish high school. And so this is what I wanted to say with this message. I thought that it was a very nice letter. I expected her to call me back or reach out to me, which is what, if I got a letter like this, I would have reached out and tried to clarify what it meant, but I just got radio silence.
So you never received a response to this email?
No. I then started to call her daily to see if she would talk to me on the phone about this, and she didn't pick up the phone. She did, I think at week 2 or 3 after this, she sent me a very short WhatsApp saying, we will not move out of our home. I can look at stuff that's being rented in the area so that Felix can go to school. I'll be happy to help you with that. And that was it.
What year of school was Felix started?
He was supposed to start 10th grade.
And he's in 11th grade now?
He's in 11th grade now.
Okay. Was there anything that you heard in Mr. Badham's testimony? Was there anything that he testified about that he got wrong?
There was one thing when Mr. Withers asked about, have you ever done any work to a property that you've rented? And I could remember several, but in particular, in 2018, we moved into a very old apartment in the middle of Bordeaux, France, and it was a rental, and it didn't have much of a kitchen. There was nothing there. It was just basically a space. And I said, we need a kitchen. And we went to IKEA and ordered a kitchen and put it in. We knew we weren't going to get reimbursed for it, but I sort of divided the cost of the kitchen by 4 years that we were going to live there and said, okay, our rent is X instead of this. And now we have a kitchen. And we knew we were going to leave it there. We weren't going to get any money back, but just made our life comfortable. And
Getting back one real quick to this email on plaintiff's 11, it looks like you specifically gave Ms. Gunbie a date of July 15th to vacate by?
yes, I wanted to be fair and also to abide by the law. And when I was writing this email, I assumed that she didn't really know what was going on. So I wanted to give her the proper 60 days notice. So I said, hey, I know that Keith has been talking about this with Matthew, but maybe she didn't know. So I wanted, take the 60 days from today. Because I need you to be out by July 15th so that we can get beds in there and get Felix to school. So that was the purpose of that.
Is there anything else I haven't asked you that you feel like you need to tell the court today?
I feel like this is very unfortunate, and that's the only last thing I'm going to say is that, we thought we were doing all these questions about, it seems that everything gets deconstructed. And the story is that we always thought they were our friends and that they were honorable people. And even throughout, I guess it's kind of like the story of the frog in the water, that you're in the water and the temperature starts to rise slowly and you don't realize until, gosh, I'm getting cooked here, I got to jump out. And that's when we had spent all our savings. We were paying rental in a house in Spain. We were paying all the expenses in a house in Atlanta. We had no income. And they were happily enjoying a vacation apartment that they rent in the middle of Barcelona, but never paying us any money. And I thought, well, this is untenable. We can't sustain this anymore. I have to go get a job in Atlanta. I have to put my son in school, and I want to go live in the house that I am paying for. And they need to understand that they've lived a beautiful 11 years in this house. They've enjoyed wonderful times there. All their kids got together after they were living separately in different apartments when they didn't have a home. And, they came together and enjoyed all that life, the termination of their youth, their marriages, whatever. Now, isn't it fair that we go now back to our house? And what I expected was for them to say, Liliana and Keith, thank you for having helped us for this time. I didn't expect a letter from a lawyer. And that's all I have to say. But we've been living because we're still living it. We've paid $50,000 worth of rent in the apartment we're living in today. I owe $10,000 worth of storage in Spain, and I have to pay you. So I just want to burst into tears, but I don't want to embarrass myself. And that's all I have to say.
Nothing further.
Thank you. Mr. Withers?
Good afternoon, Ms. Del Rio, Badham. The kitchen that you mentioned in the apartment is that Bordeaux, France?
In France, yes.
It's obviously in France. It's not in the United States. It's tradition in Europe that people typically take their kitchens with them when they move out, right?
No, I've lived in several apartments in Spain, France, and I've never put in a kitchen. That was the only one time.
But a lot of properties are rented without kitchens, right?
I was never in one. That was the first time.
And you said that, in that when you bought the kitchen from IKEA, for that apartment, you were not under a contract to purchase that apartment, were you?
I was not.
Okay.
I was paying rent.
Right. Okay. And you said, that throughout this time, the Gunbies weren't paying you anything. That's not exactly true. They paid $452,000.
They have paid money in bits. We've been desperate, and because they were our friends, and I can't believe we did that, we've been so many long periods where they didn't pay us anything, And we've had to max out our credit cards, do all kinds of, arrangements to cover our life. And meanwhile, later, and, I had a couple of arguments with my husband about this, is Facebook, I learned that they all traveled to Europe with their boys and their wives for a family reunion, that they bought a brand new car, that they did all these things. They were never missing a payment in their apartment in Barcelona. And then we learned they were making renovations in 2020. In 2020, we did not receive one mortgage payment or one utility. Well, it's easy to make renovations and spend all your money putting gazebos up when you don't have to pay rent or mortgage. They were doing it with our money.
So they did pay you the $452,000, right?
Well, divide that by 11 years of rent, and then maybe it's a small rent that they paid for living in a beautiful house with a pool and with 3 bedrooms and a gorgeous fireplace. So, nobody gets to live for free. I don't know that anybody gets to live for free anywhere. We didn't.
Sorry, my question was, they paid you $452,000, correct?
They paid a small amount of money to live in a house where they never worried about a bill. They never worried about getting their lights turned off. They never worried about, I wonder if the water is paid, or if my house is going to be full of bugs because pest control hasn't been paid. So I think they paid barely what they needed to pay to live there for 11 years.
And that amount, that bare amount that they paid was in the neighborhood of how much?
It was in the neighborhood of what my husband who has the numbers here, has told you.
You would agree as well that there was no written lease agreement between the parties, correct?
We were friends, so we basically borrowed the house from us. And Kim was under the impression they were paying rent, but from the moment they moved into the house.
Forgive me for interrupting. I understand where you're going. So this is not a natural process, people testifying, because it's not how people talk, right? So I understand. But it would be very helpful for me, for Mr. Withers, and for the court reporter, when you get asked a yes or no question, you are absolutely entitled to explain your answer.
Okay.
But it would be very helpful if you could start with a yes or no, if that's a possible answer you can give.
Okay.
And then explain.
All right.
And so just for the record, Mr. Withers, if you will please re-ask your question.
I will. Honestly, I can't remember what the question was. Madam Court Reporter, can you read back the question?
Yes.
Oh, I remember the question. Never mind.
Okay.
The question was, there was never any written lease agreement between the parties, was there?
No.
Okay. In Exhibit 11, that your plaintiff's Exhibit 11 that we just looked at, you wrote, "We always thought you would end up purchasing the Colwood house, but throughout the years, the agreement remained a lease." But, violated the rule, sorry.
Don't worry about it.
But there was no lease agreement, right? No written lease agreement.
There was no written lease agreement. I was referring to a decency agreement that you don't get to live in someone's house for free, and they were aware of that.
Okay. You were aware of the agreement between your husband and Mr. Gunbie by which your husband agreed to sell the property to the Gunbies, right?
Yes, I was.
You did not participate in those negotiations, though, did you?
I did not.
And you didn't receive notices of the payments that Mr. Gunbie made towards the purchase of the property, did you?
Every time he sent a payment, Keith showed me the running chart. And where they were in payments.
But he didn't tell you about each and every one of those payments, did he?
Everything that was in the spreadsheet, yes. And I saw the spreadsheet.
The way you know about the payments is because just of what Mr. Badham told you, right?
And showing me the spreadsheet, yes.
Okay.
A spreadsheet that Matthew agreed was right.
Okay. You didn't have a conversation with Matthew about the spreadsheets, did you?
No, but I saw his emails.
Okay. You never had any discussions directly with Mr. or Mrs. Gunbie about the amounts that they allegedly owed, did you?
No, we weren't allowed to talk to Mrs. Gunbie about anything pertaining to this deal or any monies that were exchanged.
What about Mr. Gunbie? Did you have any discussions with him?
No.
You were aware of the consulting contracts that Mr. Gunbie had secured for your husband in the Middle East, right?
I was aware that he told him when Keith was looking for a job, he said, why are you going to go look for a job? I have something for you. Why don't you come with me to the Middle East and do some consulting work?
You didn't have any discussions with Mr. or Mrs. Gunbie about those contracts, did you?
No.
And you were aware of your husband's employment with Mr. Gunby's company, Connaught Services, right?
I was.
Okay. Didn't have any discussions with Mr. or Mrs. Gunbie about that employment, did you?
No, we weren't allowed to tell Mrs. Gunbie anything that had to do with business.
That's what your husband told you?
Yes. And I knew for a fact it was true.
How did you know for a fact that it was true?
Because in 2016, when I came to the U.S. to celebrate my 50th birthday, sorry.
Age yourself, ma'am. Don't do that.
Sorry. My 50th birthday, Kim organized a party for me in the house. Well, that was one instance. She organized a party. Keith asked her to do it, and all my friends were invited, and we had a surprise party for me. They had a surprise party for me in the house. And she told one of her friends, and I sent her, as a thank you for organizing everything, I sent her a little message. It was a WhatsApp message. Thank you. It was so nice. It was lovely. And she told her friend Lynn, who told me that, Kim doesn't feel that you appreciated enough what she did for you. And I thought, at that point, they had been living in our house for 2 years without paying any money. And I thought that's why she was doing the party, because she was so happy that, that she was living there for free. Another similar thing was the year before, in 2015, we went out to dinner because I visited Atlanta, and she told me, she was telling me about this new lake house they were buying, and they hadn't paid us one payment for rent, for utilities, for anything. And she told us that she was talking happily about how they were purchasing this new lake house and how fun it was going to be. And I called Keith. It's like, how are they buying a lake house? I thought they couldn't afford to pay us rent. So Keith told me, well, it's because she doesn't really know that that's happening. But still, if they're buying a lake house, and then Matthew explained something like, oh, no, we're not really buying a lake house. It's just some friends who are letting us use their lake house, and Kim wants to buy it, but I don't think we're going to be able to afford it, blah, blah, blah. So there were so many signals. She traveled to Spain while we were there, and she never called me. She never said, come on, let's go have a glass of wine. She avoided me. All these renovations, they only called us to tell us about air conditioning or roof or boring things. She never once said, Liliana, guess what? I'm building a gazebo. Let me show you pictures. Or I'm in Barcelona. Let's meet for a drink. It was like this was so secret and sneaky that they didn't want us to know what they were doing in the house. So the whole thing feels like a big betrayal and deceit.
Thank you. Do you remember what my question was?
I remember that you asked, did Mrs. Gunbie, how did I know that she didn't know anything? She didn't know because she said, you wouldn't be bragging about buying a lake house when you owe $50,000 in rent to somebody.
Thank you. And specifically, my question was about the business relationship between Matthew and Keith, and the contracts and Connaught services in 2018 and after, right? So am I correct? All the events that you've just discussed, those were back in 2015 and 16, right?
Which events?
All the stuff that you just
The
described.
lake house and my birthday was still, they were living in the house, but it was prior to 2018, yes.
You were aware of the personal loans that your husband made to Mr. Gunbie, correct?
Yes.
I just want to, I've let it go a little bit, but I'm just going to object. I mean, this is all outside the scope of direct. I mean, it was very limited direct and pretty broad range.
That's fine. I can call her as a witness on mine if you like.
Okay, I mean, I'm willing to let you have a little bit, but he is right. It is outside the scope, but I also don't think it's worth our time to make you recall her again.
Right. I just have a handful of more questions.
Sure.
It won't take very long. You testified at your deposition that in the summer of 2020, you suggested to your husband that he should declare the Gunbies in default of the May 5th, 2018 purchase and sale agreement.
Yes.
Correct? And you suggested to your husband that he should terminate the purchase and sale agreement, correct?
Yes.
And your husband disagreed with you, correct?
Yes.
And so even so, before April of 2024, you never suggested to your husband that you should seek to evict the Gunbies from the property, did you?
I did. I said we should ask them to leave and give us back our house. But it was 2020, which was the pandemic, and Keith said, well, you know, they're never going to get a house in the middle of the pandemic. Matthew's in the Middle East. What's Kim going to do? How is she going to move? And, you know, blah, blah, blah. And we always considered them friends still, even despite all of these things.
Okay. You didn't want to throw them out of the house, correct?
No, they're not my friends. Why would you want to throw out your friends?
And you never saw any written communication that your husband sent to Mr. Gunbie advising Mr. Gunbie that the May 5th, 2018 purchase and sale agreement was terminated, did you?
I'm sorry, repeat the question. I don't understand.
Never saw any written communication from your husband to Mr. Gunbie advising Mr. Gunbie that the May 5th, 2018 purchase and sale agreement was terminated.
No, but we did talk about that's finished. That agreement is finished because they didn't comply with the terms.
I understand. I'm not talking about conversations that you had with your husband, I'm talking about conversations between your husband and Mr. Gunbie. Did you ever see any of those communications regarding the termination of the purchase and sale agreement?
No.
Okay, that's all the questions.
Thank you. Anything else for this witness, Mr. Downs?
No.
Okay, thank you, ma'am. You may step down.
Yeah.
Mr. Downs, do you have any additional witnesses or evidence to offer?
The only thing I would offer is my evidence on attorney's fees.
Okay. I feel like if the parties are amenable to that, that the issue for me is going to be entitlement, not amount, because y'all can, if I say, I think you're entitled to attorney's fees, if you can do it quickly, we can go ahead and do it right now. Otherwise, you can submit it on paper later if you wish.
It's up to you. It's up to you, Your Honor.
Go ahead then. If you'll just take a moment, you're welcome to stay in your place.
Okay, all right.
I mean, unless Mr. Withers wants to make you get on the witness stand and swear and he wants to cross-examine you.
I may have some cross-examination questions, but
That's fair.
I'll.
So he does want me to get up there.
No, but I'm saying you can stand in your place here.
Right. Both of you are officers of the court, and as Manley Brown likes to say, you can state in your place. Go ahead, sir.
All right. Sure. This came with the shared file. I'm not sure you're able to access it. All right. Well, good afternoon, Judge. My name is William Downs. I'm an attorney licensed to practice law in the state of Georgia. I've been licensed to practice since 2006. Practiced primarily in the areas of civil litigation, landlord-tenant disputes. For this case, I started out at an hourly rate of $375 back when this case started in 24. This year in 25, the rate increased to $395. And I have supervised various staff throughout the course of this litigation whose billable rates are lower than that. $375 to $395 is a fair and reasonable rate for attorneys who practice in this area in Atlanta, Georgia. Our firm has a total of 163.6 hours, and this is just invoiced hours. This was invoiced as of, I believe, October 9th. So 163.6 hours. The total billable amount was $57,763. Total billable expenses were $3,425.28. And I'm happy to mark this. I did not mark this as an exhibit, but I'm happy to, I've got an extra copy. I can mark this as an exhibit for the court. But all of the work that we did on the case was reasonable and necessary to prosecute this case. And it encompassed, pre-suit demand, filing suit, motion to compel rent hearing, limited discovery, exchanging written discovery, conducting depositions, dealing with the motion to transfer, and then preparing for trial here today.
And you said the total amount of cost was $3,425.28 up
That's right.
to October 9th.
October 9th, the total billables amount
$7,000 and
$763. And then I would just, I didn't know how to estimate for trial prep purposes or, how many days of trial we would be proceeding. But again, my rate is $395 for this case. I would estimate 10 hours per day of trial.
okay. Okay. Thank you, sir. Did you have questions, Mr. Withers, for Mr. Downs regarding his attorney's fees? And hang on, did we feel he's going to provide me with a copy of thank you, sir. And this is, it looks like a printout from probably whatever your internal billing system is, a series of printouts.
That's right. The first page is a summary, and then all the invoices, all the actual invoices are attached.
Okay. And these have been provided to you, Mr. Withers?
Just now.
Excellent.
Well, I thought our office said they provided them yesterday, but.
That's fine.
And what do you want to designate these, Mr. Downs? Plaintiffs?
We're plaintiffs, in the notebook, I believe does it start with plaintiffs 12, is that right?
Your last one was 12, so this would be 13? Okay. Okay, Mr. Withers.
I do a P11 for the last, or it could be.
Oh, he may not have offered, he may not have specifically asked a witness, but he offered D1 through 12, and I admitted all of them with certain exceptions that we discussed on the record.
Okay, thank you.
Mr. Withers, questions?
Yeah, not many, because I've been in that position before and it's not any fun. And by that position, I mean being cross-examined on your invoices.
Yep.
Have you, are these time entries here, is this for everything that you've done in the case?
That's right, yes.
Okay. So these are for the fees that you've incurred in prosecuting the Badham's claims, correct?
Prosecuting Badham's claims and anticipating your question, defending your counterclaims.
Okay. And how much have you broken this $57,000 down into what is attributable to prosecuting the Badham's claims and what is attributable to defending against the Gunbie's counterclaims?
No, I have not done that calculation. The time entries reflect what the work was done for.
Okay. That's all the questions that I have, Your Honor.
Okay. Do you want to redirect yourself, Mr. Downs, on any of those questions?
I think I will not.
Okay. Thank you. Do you have any other evidence to offer on behalf of the Badhams?
No, plan for us.
Okay, thank you, sir. Mr. Withers.
Yes, at this time, Your Honor, I am going to make a motion for a directed verdict.
Okay. Briefly walk me through the
I will.
basis of your motion, sir.
Your Honor, as an initial matter, I don't think the plaintiffs can prevail on their dispossessory complaint because there's no landlord-tenant relationship between the parties. Testimony is that there was never a lease between the parties. There was never any written rental contract between the parties. The only payments the Gunbies ever made with respect to the property were toward the purchase price. OCGA 44-7-1A provides that the relationship of landlord-tenant is created when the owner of real estate grants to another person who accepts such grant the right simply to possess and enjoy the use of such real estate, either for a fixed time or at the will of the grantor. Here, the Badhams did far more than grant the Gunbies the right to simply possess and enjoy the use of the property. Rather, the parties entered into a purchase and sale agreement, and that the Badhams never terminated that agreement. I understand that there is, argument, and you've only heard half the evidence, that the agreement terminated, but the fact remains that, there was certainly never any written notice of termination.
So here's my one question I have. I acknowledge, as you correctly pointed out, I've not heard all of the evidence. But if the court were to determine that the purchase and sale agreement ended by its own terms, regardless of what anybody thought about it, then what is the status of the Badhams relative to the Gunbies if it's not landlord-tenant in common, at sufferance, as holdovers, in whatever way you want to call it?
I think, and that's a good question, and I think that it would be equivalent, and I'm not sure what the legal term is, but, essentially, as the purchase and sale agreement says, it's going to be owner financed. So if we look at it in the context of a mortgage, essentially, then, if I don't pay my mortgage, that doesn't make me a tenant of my mortgage company. The mortgage company has to go through certain procedures to foreclose. And then once they have established that, then they can move to evict me as a tenant at sufferance. But I don't believe that happened in this case. And I would argue that, that's, again, I'm not sure what the legal term is for that, but
your position is that as an owner, right, a financer, one who holds a mortgage, whatever we're going to call it, that they have different legal remedies than a landlord does, and that if they wanted to exercise remedies, they would have to have done it under the agreement.
Right.
Or as owner financiers.
They would foreclose, and which didn't happen here. And then I think you could probably do a dispossessory, but it's, obviously it's our position that the purchase and sale agreement never terminated in the first place because of what, testimony that you'll hear. But I don't believe that there was a landlord-tenant relationship. And further, the Georgia Supreme Court has held that where there is a sale or contract of sale of title, the relation of landlord and tenant does not exist, but it exists only when the use of land, either for a specified time or at will is granted. Now, I want to ask you to keep a straight face here, but that is Allred versus Harris, 75 Georgia 687 from 1885.
Okay.
However, it is still good law. And in May versus May, 165 Georgia Appeals 461, 1983, the Court of Appeals relied on the Allred case in distinguishing the relationship in that case from the relationship in Allred, noting that Allred involved an agreement between the parties purporting to convey title. This necessarily negated the existence of a landlord-tenant relationship.
How do we reconcile that, though, acknowledging that it's perhaps good law and was not negatively referenced by the Court of Appeals more recently, although I think I was still in elementary school when that happened. How do you reconcile that, though, with the fact that there is no security deed, there is no warranty deed, there is nothing other than this purported agreement between the parties that would grant any secured interests to the Gunbies? How do you reconcile the case law you've just cited to me where they're talking about title with the fact that the only title we have is a deed that says the house belongs to the Badhams?
Well, the agreement itself says that within 30 days after, or 60 days, I don't have it in front of me, title will be conveyed.
It's 30 days after the
30
balloon
days.
payment. Yes,
So
sir.
there is talk about conveying title. Whether you enter into a security deed doesn't change the nature of whether it was a purchase and sale contract as opposed to a lease. You don't have to have, I would argue, I cannot imagine a professional lending company entering into an agreement without doing a security deed. But I am aware of no provision under Georgia law that says that an agreement to convey title to property must be accompanied by a security deed. So that would be my response to the court's question.
Okay. Thank you.
The Georgia statutory scheme for dispossessory actions under 44-179 et sec, which is the statutory scheme under which the plaintiffs have brought this action, it only applies to landlord-tenant relationships. And because there is no landlord-tenant relationship in this case, I contend that the plaintiff's complaint necessarily fails as a matter of law. Additionally, the allegations in this case are set forth in the dispossessory complaint, which they filed in the state court of Fulton County before the court was transferred to this case. They allege that the tenant fails to pay the rent, which is now due. Tenant holds the premises over and beyond the term for which they were rented or leased to the tenant. Plaintiff demands possession and past due rent of $97,460 since November of 2022, plus utilities. They demanded $150 a day, interest at the rate of 7% per annum, and then, of course, the attorney's fees. I would argue that they have failed to establish that the Gunbies failed to pay the rent that is now past due. Mr. Badham testified that the parties did not enter into a written lease agreement for the property. Section 2.7 of the purchase and sale agreement expressly states that during the term of this agreement, the buyer will have the right to occupy the property as a private residence and no rental payments will accrue or be payable. Mr. Badham also told Mr. Gunbie in writing, and again, I know the parties just have different interpretations of this, that the agreement did not end on July 1st, 2021. He continued to accept payments. And finally, the plaintiffs have put forth, I would contend, no evidence as to the amount of rent that is actually due, which according to their dispossessory complaint was $97,460. Mr. Badham testified that he contends that some of the payments the Gunbies made were for debts other than amounts owed under the purchase and sale agreement. So I don't think there's any evidence in the record as to the amount owed under a lease agreement that never existed. And the plaintiffs cannot prevail if they cannot demonstrate the amount of alleged rent that the defendants allegedly owed.
Well, I know there wasn't a written lease agreement, but didn't the lease agreement functionally exist between 2013 and 2018? And I know there wasn't a written agreement, but the parties were operating under some agreement for the Gunbies to have possession.
Right.
And pay something.
Okay, let's assume for the sake of argument that there was an agreement for the payment of rent in.
Because otherwise legally they'd be squatters, right? And there would be a whole different set of remedies that would be available to the Badhams, correct?
Well, I'm sorry. I want to make sure I answer the court's question. Are we talking about between 2013 and 2016?
Yes. Well,
18?
Yes. Because you mentioned there was never a lease agreement. And I agree there's an open question we've got to find an answer to starting in 18 and really more importantly after 21. But when you said there was never one, my question was, but wasn't there de facto a lease agreement or rental agreement or a tenant at sufferance or something happening between 13 and 18?
I think as I stand here, I would agree that it was either at will or I don't know if at sufferance is the correct term because it was certainly with the Badhams' approval. But, you know, at least as to that period of time, there was a discussion, I believe the testimony from Mr. Badham was that there's a discussion that he wanted X amount, and Mr. Gunbie said, I can only pay $1,400 a month. And so, at least during that period, if we limit it to that period, perhaps based on the evidence you have today, maybe it was $1,400 per month during that period. However, there is, I can't remember what the statute of limitations is on a oral contract. I think it's 4 years. It's certainly no more
It's
than
4 if it's not written and it's 6 if it's written.
Right. So there can be nothing owed for that period. The statute of limitations on anything that happened before May 5th of 2018 is barred by the statute of limitations.
Right, and I didn't mean to imply otherwise, except that, for lack of a better way to frame it, if this was a dispute between two corporations in a commercial context, this would definitely be a course of dealing type analysis. And so, to my way of thinking, the nature of the relationship prior to the purchase and sale agreement is relevant to a consideration of what is the status of the parties and what remedies and rights flow to each party. Not that it's outcome determinative or dispositive, but I think it's informative. So that's why I wanted the answer.
I understand. And that's a fair point. I would simply argue that whatever the relationship was from 2013 to 2018 ended when the parties materially changed the nature of their relationship as set forth in the May 5th, 2018 purchase and sale agreement. So the third thing is they asked the court to compel the Gunbies to pay $150 a day, which comes out to approximately $4,500 a month. Yet before this case was transferred to this court, in its November 1st, 2024 order, the state court of Fulton County ordered the Gunbies to pay $2,580 a month into the court's registry while this case remains pending.
Right, but wasn't that because the court was concerned from a fairness and equity perspective of covering the specific expenses, not the value, but the expenses associated with the house?
I would agree that in fairness, this was a situation where the state court said, I want you to both draft proposed orders. Mm-hmm. She rejected my proposed order. She accepted Mr. Downs' proposed order. Mm-hmm. I can't speak to what Mr. Downs meant when he put those numbers in there, but I do think it is a fair assumption to interpret that that's the court was trying to cover certain costs. I think I can't make a good faith argument to the contrary, although what I can say is what the statute says is that if you're going to compel them to have, you pay rent into the registry of the court. Mm-hmm. If that is what if the court felt like, if the state court felt like the rent, assuming a landlord-tenant relationship existed, should be a different amount, presumably the court would have indicated as much, but it didn't.
Well, just to be clear, I don't know if because I generally ask for orders in Word format and I will edit them. Sometimes I say, this is all good, I'm signing it. So I don't know if Mr. Downs put this in here and it was just adopted by the court. But there are 2 footnotes here that specifically say the amount and specifically say that the amount is being added based on a citation to McDonald Georgia Commerce Center because plaintiffs are being forced to satisfy a mortgage and that receiving rental payments contributes to accomplishing justice. So I think I agree with you that it's not just positive of the status of the parties, but the amount that was intended to be paid, I think, was directly, at least to my understanding, was intended to cover the costs associated with maintaining the property while the litigation was ongoing and while the Gunbies continued to possess the property.
Right. Understood, Your Honor. And my point is simply that in asking for $150 a day, which comes out to approximately $4,500 a month, number one, the rent that the state court ordered them to pay has no discernible relationship to $150 a day that the plaintiffs contend is due. As
Well, yeah, let me help me understand why you're talking about how much they might be entitled to, and here's why. Because on a DV, all I care about is have they satisfied the elements of a dispossession? And I understand your argument about they're not really a landlord tenant, so but the amount that they'd be entitled to get, unless it is a demonstration of, see, they're not tenants, I don't know that it's relevant to my consideration now, although certainly if we get past DV, it would make sense for you to make the argument that I shouldn't include that in the damages because that's not part of the relationship.
the relevance is, it's only relevant to the notion, not only do you have to prove that there was a landlord-tenant relationship, but if you are seeking rent, which they are, it's in their complaint, you have to prove your damages with a reasonable degree of certainty. If you can't do that, and that's an element of a claim.
Isn't there a zestimate in the record, right? I mean, didn't Mr. Badham testify that he looked at Redfin and he looked at Zillow and that there was a range and he picked the midpoint and it was somewhere around 5,000?
He did.
Okay.
And I don't believe that, I mean, I realize there's case law that says, generally a party he doesn't have to be an expert as to testify to the value of his or her own property. Mm-hmm. You can offer that testimony and it doesn't have to require expert witness testimony. But, here, we're relying on hearsay as to what the reasonable value of that is.
Sure. There's at least I don't think there's case law that says it, but there's at least a pretty good argument that the rule on market publications and generally available commercial information, that Zillow and places like that are all readily available to us have become what was intended to be captured by whenever that rule was adopted back in the 70s. But
and I'm not personally familiar with that statute. I'll take the court's word for it, but I certainly don't know that Zillow and Redfin are authoritative on the issue is where I would leave that point.
I understand. Okay.
The dispossessory complaint expressly says that the defendant is also notified that defendant shall owe attorney's fees under 13-111 if the principal amount is not paid within 10 days of service. 13-111 expressly provides for the recovery of attorney's fees, quote, if such note or other evidence of indebtedness provides for attorney's fees in some specified percent of the principal and interest owing thereon, or if such note or other evidence of indebtedness provides for the payment of reasonable attorney's fees without specifying any specific percent, and then it provides, the formula. But here, of course, there is no lease or other evidence of indebtedness that provides for the recovery of attorney's fees, and therefore I believe that section 13-111 is entirely inapplicable. And as to, Mr. Downs filed an amended complaint that asserted a
13-611.
13-611.
Right.
I understand that the court has not heard all of the evidence in this case yet, but, I don't believe there's concrete evidence. There might be speculation, but there's no evidence that the Gunbies have acted in bad faith, that they have been stubbornly litigious, or that they have put the Badhams to unnecessary and trouble expense, as alleged in the first amended and restated dispossessory complaint. I think in understanding that there's still evidence to be heard, there is at a minimum a bona fide dispute as to whether the Badhams are entitled to prevail on their claims. Again, we contend, and I realize this is not in evidence yet, but the Gunbies have paid over $437,000 towards the purchase of the property. That excludes the more than $77,000 they've paid into the registry of the court to cover the Badhams' mortgage payments over the last 3 years, And when I say 3 years, that's because the initial $60,000 goes back to 22.
Quick question.
Yes, ma'am.
13,611 though, to the extent that, I mean, we're in agreement that 13,611 is not about stubborn litigiousness. It's about bad faith in the underlying transaction, correct?
In the underlying transaction.
And that would be sort of the ongoing relationship from 2013 to now until we get to litigation, right?
Yes, ma'am.
Okay. But 91514 would be the analysis of whether there'd been stubborn litigiousness, et cetera, correct?
Well, no, okay, so.
I'm sorry, I didn't say that very well. I understand that one of the defenses to a 13,611 claim is that there's a bona fide controversy.
Yes, ma'am.
And that the Gunbies, no doubt, are going to argue that they believe they had a legal right to possession of the property and to purchase the property, and therefore there's a bona fide controversy. I understand that. I was just making sure, and again, I did not phrase it well a moment ago, that we're talking about 91514 is a different assessment, and that is included in the amended complaint, although albeit, I guess, potentially prematurely, because,
I don't think I did include that.
I don't think there is one, but I'm happy to be corrected if I'm mistaken. I don't.
Okay. I had written into my notes, it's entirely possible that I was wrong. Okay. So just ignore me then.
Sure. Okay. So in short, Your Honor, my motion for directed verdict is premised on two arguments. One, no landlord-tenant relationship between the parties. And second, I believe that the plaintiffs have failed to prove multiple elements of their claim, even assuming that a landlord-tenant relationship existed, which we contend there does not. So therefore, we respectfully request or submit that the Gunbies are entitled to judgment, a directed verdict on the plaintiff's claims. Thank you.
Okay, thank you. Mr. Downs?
Need a response to that? Would you like to hear a response?
I would like a brief response, please. And I'll make it easy for you. I would like for you to focus on Mr. Withers' argument regarding the nature of the requirement, the element of being a landlord-tenant relationship, because I believe that if that's established, right, if there's facts from which I could find that, then the other matters he has brought up would not be outcome determinative otherwise. Does that make sense?
Sure.
Okay.
Yeah, they came into possession voluntarily, right? The Gunbies, Badham's allowed them to be in possession, right? OCGA 4476, tenancy of will, when no time is specified for the termination of a tenancy, the law construes it to be a tenancy at will, right? So they've always been tenants at will. They had a right to purchase agreement for a minute, to occupy the property, but I don't know that necessarily changed their status as tenants at will.
So is that because in the context of a mortgage, right? The owner is still the owner who is in possession of the property usually, right? And the thing that's being foreclosed is the security deed.
Yeah, security interest.
Which we don't have here.
This is really a lease purchase.
Right, but more, that's my point is, even under its own terms, however it's phrased, at the end of the day, is it fair to characterize this as a lease purchase because the deed never changed hands, which is emblematic of a traditional mortgage?
I think that's right. Just I will retract that and say I think this is more like a lease purchase. Mm-hmm. So during the 3-year period of the term, they had a right to be there. After that, we kind of get back into a tenant at will situation, right? Okay. You no longer have the right to be there once the agreement is terminated, right? You're only there with the permission of the owner. And so I would just cite the court to Morris versus Brill, which is a little more recent than 1885. It's a 2005 case, 275 Georgia App 293. And it's essentially what we have here. In that case, the tenants had a lease purchase to buy the property, made payments, in this case, made payments under the lease purchase, but didn't make all the payments. Didn't comply with the option terms to purchase the property, but stayed in the property after the term. continue to make the payments after they stay in the property. And, it's, in that case, there's a dispossessory that was filed. And, it doesn't say anything about, there's no landlord-tenant relationship because you have a security interest in the property, but it does defeat the tenant's claim for any sort of unjust enrichment, claims, because anytime that, you had the right to be there, but, your expectation was that you could only be there so long as you comply with the terms. And once you don't comply with the terms, now you're a month-to-month tenant. And you can be dispossessed with a 60 days notice. I mean, the fact that they were allowed to stay in the property for another several years my client shouldn't be penalized for that. If anything, that was charitable on my client's part. But it doesn't change the status of the landlord-tenant relationship. I mean, otherwise I don't really understand Mr. Wither's argument about that they're somehow owners of the property. They were never conveyed a deed like a normal mortgage and security interest would be. They never asked for a deed. They were never conveyed a deed, and they never operated as owners of the property. So I don't really get it. I mean, it's a dispossessory case. I mean, how else are we supposed to file this thing? I mean,
I don't know. You'd be surprised the number of times I've dealt with ejectment actions recently.
I mean, they're not intruders.
Right. They're not intruders, and they're not, there's not a security deed to foreclose on.
Yeah, it's permission of the landlord. It's
Right.
permission of the owner. That's all, that's what we're doing here. So, we gave them, their tenancy of will, we terminated the tenancy of will, and, we set forward a prima facie case for eviction.
Okay. Thank you, sir. Mr. Withers, any response?
Just briefly, what was that kid's name?
275 Georgia App 293.
293. Got everything but the page. I would just disagree with the notion that this is a lease purchase agreement. It wasn't. There's no lease. But in any event, I just reiterate that I do not believe that they have established the existence of a landlord-tenant relationship, and in the absence of that relationship, I don't believe that a dispossessory is the proper method. Maybe an action in ejectment is, but that's not what how they chose to pursue this case. I would say, well, I'll close with, understanding that the court has only heard one side of the story and is therefore only at this point allowed to rely upon the evidence before the court at this time. I believe that the evidence at this time that fails to show the existence of that landlord-tenant relationship.
Okay.
Thank you, Your Honor.
Thank you. I am going to deny the motion for directed verdict. I mentioned before Mr. Downs started talking that I didn't think that the other elements of a dispossessory action were going to be outcome determinative for a DV, and that what I mostly wanted to hear was to address the status of a tenant-landlord relationship. And I think that for purposes of a DV, obviously there is a dispute about the import and effect of the purchase and sale agreement. But for now, I think that it survives the DV, and that there is evidence from which the court could find that a tenancy at will relationship existed, and therefore a a dispossession is an appropriate remedy. So there you go. Okay, so now it's almost 5 o'clock. The question is, I expect, because just based on the amount of time that it took for Mr. Badham's testimony, I expect Mr. Gunbie's will take some time. But I didn't know if we were also going to hear from Ms. Gunbie, or if you had other witnesses that we might fill some time with, or, if we want to, how much longer do you think we have to go for your case and counterclaim, your defense and counterclaim?
Right. I would say to the court, at this time, I only intend to call Mr. Gunbie.
Okay.
If I feel that Mrs. Gunbie's testimony is necessary, then I would reserve the right to call her.
Mm-hmm.
Those are the only witnesses that I intend to call. I would note Mr. Gunbie is in either Saudi Arabia or Bahrain.
I was wondering about the time difference. It must be the middle of the night wherever he is.
Getting close to midnight, if not already a little after. Given the amount of time, and that he is the last witness, the only witness, at least at this time, that I intend to call. And if I do call Mrs. Gunbie, it will be like Mrs. Del Rio Badham, very short.
Okay.
So my respectful suggestion to the court would be that we adjourn for the day so that Mr. Gunbie can go to bed, and resume to.
Okay. What are your thoughts on that, Mr. Downs?
I'm fine with however the court prefers.
Yeah. I mean, as much as I would love to go ahead and get started, it doesn't make a whole lot of sense to just try and get, 30 more minutes of testimony in. And so I think what we will do is adjourn here in a moment, resume in the morning. I don't have any meetings tomorrow morning, so would like for us to start promptly at 9:00, which hopefully should be easy for Mr. Gunbie to do because it'll be mid-afternoon for him at that point. But I will be here and we'll have another Zoom set up. I don't know if we've provided you with the link for that, but if Mr. Freehoff has not set it up yet, he'll make sure that he does so that Mr. Gunbie has it.
And so it's, to be clear, it is not the same link.
It will not be the same Zoom link. We create a new one each day. I don't know why, but that's just how we do it.
That's fine. I don't have it yet, although I have a bunch of emails that haven't gone through today.
Okay, Mr. Freehoff, if you could please, if you have not already created the Zoom link for tomorrow, if you could go ahead and create it and email it to the party so they have it and can provide it to Mr. Gunbie as soon as possible.
Yes, Judge, I'm doing it right now.
Thank you so much.
And I don't know if you want this on the record or not. I just want to get a little bit of clarification as far as procedure for tomorrow. Your Honor said that you might have letter briefs. I don't recall the exact.
Sure. Madam Court Reporter, I think we are adjourned for the day, though. It's 4:54 and we're going to be done for the day. So thank you very much.
You're welcome.
Okay, and so we are off the record. Yeah, I mean, I don't always do it, but what I typically do when I'm sitting as the fact finder is I ask the parties, instead of making a closing argument like they would to a jury, to write me something that outlines their argument about their position. And then what I also ask is a proposed verdict or judgment. And by that, I don't just mean like you would for a jury trial. Here's the questions we need you to answer, but your suggested answers to those questions, whether it's dollar amounts or whether it's a finding in favor of one or the other on a particular thing. I mean, just based on the half of the case that I've heard yet, and having not heard anything about the counterclaim, right? I mean, clearly what the court has to figure out is whether or not the Badhams are entitled to a dispossessory. In other words, which one of these parties is entitled to possession of the house? And then whoever is entitled to possession of the house, what of the others' claims and substantial financial interest and or contribution that have been made. And so, I mean, that's still the problem that's the baby I have to split. So that's what I will be looking for in terms of resolving the issues. And so what I expect I will do is hear from Mr. Gunbie tomorrow. Ms. Gunbie, if she testifies, anything else from Mr. Downs, if there is any rebuttal. And then we can play it by ear, but I expect that what I will do is say, hey, I'm going to send you all home now, please, in the next 4 or 5 days. Like, now, I don't want to wait too long because I want it to stay fresh with my notes. Tell me, write me a 4 or 5 page, whatever, saying this is my closing argument, and send me a proposed verdict, proposed judgment. And then what I do from there is, now, if I grant a writ of possession to the Badhams, that will be entered as a separate document. I mean, I'll enter a verdict that says I think they're entitled to a writ of possession, and then I would issue a separate writ. But in terms of the final judgment, I typically would I would enter a verdict, I would enter the writ, and then I would ask for whoever I was ruling in favor of to prepare a final judgment for the court to enter, because obviously the deadlines for y'all to do things other than the writ run from the judgment. So does that make more sense?
It does.
Okay.
And because I think I understand, I just want to make sure I'm going to have a much more free evening tonight than I.
Yes, you do not need to prepare a closing argument tonight. What I am expecting instead is for you, and to be clear, I don't want mean, if the law is helpful and that's what you'd be arguing, then make legal arguments, but I don't need you to write me a brief, right? I mean, I really do want it to be a closing argument. I just would like for it to be in writing instead of verbally.
Okay,
Okay,
sounds good.
thank you.
All right.
And
Thank you,
Judge,
Judge.
how did you say you're related to Chesley?
So Chesley's grandmother, Thelma Lou McLeod,
Okay.
is my grandmother, Margie Nell Harrell's sister. They both grew up as Margie and Thelma Simmons,
Okay.
and they are sisters. Although his grandmother has passed on, my grandmother just turned 100.
So that, the
I know.
only thing I learned from Trust and Estates class in law school that I remember is that makes you guys second cousins.
Oh, there we go. Well, you know, Judge Paget, who's now on the Court of Appeals, his actual discussion with jurors actually explains, because, you know, one of the questions we ask is, you know, are any of you related within the second matter of
Consanguinity.
right, of consanguinity to the DA, if it's a criminal case. And he actually explains to the jurors what the levels are. And I'm like, I don't even understand it. I wouldn't even try to explain.
I get so confused with that stuff.
So are you from, I grew up in Hazelhurst.
Right. So my grandmother moved away to the big city of Macon.
Ah, gotcha.
So I'm from Macon.
Gotcha. Okay,
Right.
great.
Yeah.
All right.
But I might actually, I mean, this case just happens to be on my docket. It's not one that would have gone to the business court, but I see you guys more in the future because I'm going to be one of the business court judges now.
Oh, okay.
Okay, great.
Yeah, so.
I've never filed anything.
Well, a lot of times not the metro, I mean, just the metro one here, not the state one. The difference that's interesting about the metro is that consent is not required.
Okay, yeah.
Right. So if I, and I've done that recently, said, I think this case should be in the business court, and I'll say, hey, lawyers, do you think we should send this to the business court? And they say, yeah, this is a good fit, and it goes over there. And now the funny part is when I get over there, I might get back a couple of cases that I sent over there saying, I don't want to handle these, send them to the business court. So
Right. Gotcha.
thank you all for your time. I will see you tomorrow morning at 9 a.m.
Yeah.
Thank you, Judge.
Thank
Thank
you.
you.
Okay.
Oh, what about the,
Yes, absolutely. Yes, sir.
what about the exhibit binders? What should we do with those?
So you're doing anything else, and he's gonna, as soon as y'all walk out of the door, he's gonna lock it, so y'all can leave whatever you want in here.
Great.
All right.
I just have.
Even,
one
can I also
clarifying
read
question.
this rolling thing that I?
Yes, absolutely.
All right, great.
No, that was just for reference. It wasn't, you're letting me turn to speak.
It was admitted.
Okay.
Earlier by the judge, like, there was no dispute as to all that stuff.
Yeah, so then this is 12?
13. I think we called it 13.
Because we ended at 11.
I've got 12. I just, yeah.
Okay.
No.
13 is sort of-
But 13.
13 for, okay, and then that's 11.
11 was the email, yes.
Got it.
Yeah.
Okay, sorry, I didn't want to
Yeah,
go, okay.
Madam Court Reporter, this might help, because this is what I was looking at.
Okay.
So see how he's got a list of 12?
Oh, okay.
Right, so what I do is I just listed them all in mass except for the ones that are marked through.
Got it.
And so that's why he and I both know that there definitely was a D12. He just might not have talked about it
Okay.
during the court.
Okay, thank you.
Thank you all.
What's that? Yeah, we just need those. Yeah, absolutely. Have you been, I think I had a Zoom hearing with you where you were saying one of your children had started school at UGA?
Yeah, so I have my older one is she's going to graduate next semester from FSU. And my middle one just started at UGA this fall.
Okay.
And boy, talk about living your best life. Whew. I wish I could go have that much fun.
Son or daughter?
A daughter, she went through Rush and she's made all sorts of new friends, and she's a big football fan. And so she wasn't happy about her dorm because she wanted Cresswell and, you know, all the fun ones.
That's terrible.
But it is, of course, it's horrible, but apparently that's where all the fun is.
I would not be there.
That's where I was.
But then we went to her dorm and she realized that